Yeah. That's the sign that you better have, you better something like that. So it's nice to create an account. Is that one lens? Yeah, I think so.
Thank you, everyone.
What? Jackson.
Hey, Judge. And this room.
Thanks, everyone, for your patience. Grand jury selection took a little longer today.
It's all right. I didn't expect it, so. Hopefully, it won't be so long.
I learned a little bit today, Judge.
Oh, yeah?
That was the first time I've ever seen that. 25 years, first time I've ever seen that.
Well, now you know the huge burden that the state bears in getting a true bill. The
Just
one
how the
that
process-
indictments made it through, huh?
It's just how the process goes. You know, you can leave the room if you like. I never heard that.
Yeah.
Sorry.
Yeah, they're just using your losses.
Ms. Dilligard, good afternoon. Because we have Mr. Ponder on from GDC, and he's probably been waiting a while, or more accurately, we've been tying up GDC's equipment. My thought is we'll start with that plea, and then we'll dive into the rest of the calendars. Are you ready to go on? And we also have Mr. Williams on. Are you ready to go with that?
Yes, Judge.
Let's do that first. Are you going to be at the witness place or right there? You can be in either place. I just need to know. I'm going to add it if we need to add it, but if the prosecutors are going to be up at the witness stand, then I don't need to add the prosecution camera. Okay. You're committing all your colleagues to the same.
Oh.
That's fine. They can deal with it. You're the trendsetter. Mr. Ponder, are you able to hear us?
Yes, sir.
Great. Thank you. Well, I'll tee this up while Ms. Dilligard is getting up to the witness stand.
Sorry.
That was Ms. Rios for the record. This is 23 SC 187643, State versus Ponder. Mr. Ponder is in custody down at Wheeler. His lawyer, Mr. Williams, is appearing virtually. Ms. Dilligard is here for the state, and we are on for what I understand is the plea in the matter. Mr. Ponder, for the most part, you're welcome to remain on mute there in case there's background noise. Well, actually, I'm going to have to reverse that. You're going to be answering a whole bunch of questions, so you won't be on mute. So I'm going to ask you to unmute because I need to ask you a few questions before Ms. Dilligard swears you in and we get started. You are appearing virtually, which is fine. You've got a right to do that. But in doing so, you're waiving a couple rights. One is your right to be here in open court, and the other is the right to have Mr. Williams by your side. He is also appearing virtually, and you can see him on the screen. Are you comfortable, Mr. Ponder, waiving your right to be here in court as well as your right to have Mr. Williams by your side?
Yes, sir.
Okay, if at any point you want to speak with Mr. Williams in private, let me know, and I'll move the two of you into a breakout room where you can speak in a way where no one else can hear you. I mean, anyone in your room could hear you, but we couldn't hear you. I don't think you'll need that, but that's your decision, not mine. Will you let me know if you need to do that?
Yes, sir.
Great. Ms. Dilligard's going to put you under oath in just a moment and then ask you a host of questions that I suspect you and Mr. Williams have already discussed. But if at any point you've got a question of your own, just stop us, raise your hand, wave your hand, do something like that, and I will do my best to answer it, okay?
Yes, sir.
All right, Ms. Dilligard.
Mr. Ponder, please raise your right hand. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can lower your hand. Please state your true and correct legal name for the record.
Gian Ponder.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you and how far have you gone in school?
28, and I have a high school diploma, 12 years.
Mr. Ponder, do you understand that you've been charged with the following offenses? 1 count of possession of a firearm by a first offender probationer.
Yes, ma'am, I do.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove that charge against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in this indictment, including the facts and circumstances relating to that charge?
Yes, ma'am, I have.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
We would so waive for purpose of this plea.
Mr. Ponder, do you remember being arrested for these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for the charge which you're pleading guilty today? It's possession of a firearm by a first offender probationer. The range is 5 to 10, since this would be your second conviction. Is that your understanding?
Yes, ma'am.
Do you understand that you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to plead to the indictment for a term of 5 to serve 2, credit for time served. And the condition of his probation would be to forfeit the interest in the firearm in question. And that's
So we'll talk about it later, but of course, one of the spicy issues in this case is which firearm we're talking about. And I suspect what I'm going to impose, just so no one's surprised, is that Mr. Ponder forfeits any interest in any firearm that was recovered from the scene of this accident. There were 2, and he shouldn't, when he gets out, go to, if they're even still around, to the local authorities saying, I want one or both of those guns.
yes, Judge.
Okay.
Is that your understanding of the recommendation, Mr. Ponder?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am, I understand.
You understand that the court has the right to sentence you to the maximum the maximum sentence on this charge?
Yes, ma'am.
Do you understand that the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're placed on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand if you fail to follow all the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am, I understand.
And do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
I am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am, I understand.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am, it is.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. Ponder, how do you plead to the charge of possession of a firearm by a first offender probationer in indictment number 23 SC 187643?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on May 23rd of 2020, officers clocked a vehicle traveling a high rate of speed. They clocked the vehicle going 90 and a 55. They activated their emergency equipment to try to initiate a traffic stop. However, the vehicle sped up to over 110 miles per hour while weaving in and out of traffic, going from one far lane to the opposite far lane. The Cherokee had rolled over and hit a curb and was on its back, had completely rolled over and was on its back after striking the shoulder. Officers approached the vehicle. All the airbags were deflated, and there was a passenger in the driver's seat, and then the defendant was in the this defendant was in the passenger side of the vehicle. He was able to get out of the car but had visible injuries. The driver was unable to exit the vehicle. It had to be excavated from the car by fire and rescue. It's my understanding that at this time that defendant is now deceased. There were 2 firearms. That defendant, the driver is now deceased. My apologies. There were 2 firearms that were located in the car, along with some marijuana. And this defendant was convicted of possession of a firearm in indictment number 17R304 on February 14th of 2019 in the Superior Court of Dougherty County.
Okay,
And all of this occurred in Fulton County, Georgia, Judge.
got it. Thank you. Good afternoon, Ms. Jackson. How are you doing?
Good afternoon, Judge. I'm great. How are you?
I am also great. Criminal history information, please, on Mr. Ponder.
Yes, 23 cycles. The last arrest was June the 6th, 2023 in Dougherty County for a probation violation and a failure to appear and trafficking cocaine and possession of Schedule 1 or 2 controlled substance with the intent to distribute and possession of a firearm during commission of a felony and theft by receiving stolen property and possession of a firearm by a convicted felon. There was no disposition listed in the GCIC for that arrest. He does appear to be on under some type of sentence out of Dougherty County for possession of controlled substance with the intent to distribute and criminal street gang activity. That disposition date was February the 14th, 2019, 4 years and 11 months of confinement and 5 years of probation. He does have a prior felony conviction that was in 2022 out of DeKalb County for possession of a firearm by a convicted felon. And he has misdemeanor convictions. One in 2018 out of Dougherty County for driving without a valid license. One in 2016 out of Dougherty County for driving while license suspended or revoked. and giving false information to an officer, and possession of marijuana less than an ounce. And there was one in 2015 out of Daugherty County for giving false information to an officer. Additional one in 2015 out of Daugherty County for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Mr. Williams.
Judge, I just want to offer just a couple of pieces of additional information as it relates to the sentence in the case. We are asking that you would accept this negotiated recommendation. Ms. Dilligard and I have arrived at an agreement that Mr. Ponder shall receive, if Your Honor will allow, credit for time served since she went into custody. Mr. Ponder has been in continuous custody since February 3rd of 2023. So he has been in custody now for over 2 years. We're asking that the court give him custody, give him credit for that time since he's been in custody. The probation case that you heard of out of Daugherty County, he's since gone back to Daugherty County on a probation violation. That's how he finds himself back in prison. He's been resentenced to a total of 10 years to serve in Daugherty County. It's a maximum release date of 2028 in this matter. Certainly, considering the facts of the case from a defense perspective, Judge, there was real question as to whether my client has possessed a gun. We feel this is a fair resolution to the case.
Got it. All right. So Mr. Ponder, Mr. Williams answered one of my questions, which is why are you in GDC custody now? And I guess it's a follow on from one of those cases down in Daugherty. Is it the drug trafficking case or the gang case, or that's all one and the same?
This will be the gang case, Your Honor.
Okay. And your release date is what Mr. Williams shared. Ms. Simpson, is Mr. Ponder on probation anywhere, or he had everything revoked?
He was adjudicated guilty on one case, and then he has another case, but both cases are straight time.
Got it. Okay. Was your first offender status revoked and then you were adjudicated guilty, Mr. Ponder? Does that question make sense?
Yes, sir.
Okay. And did all that flow from this arrest? What led to you losing your first offender status?
It was a negotiation.
Pardon me? Oh, the DeKalb case. The gun in DeKalb. Got it. Got it. Okay. Yeah, because this is particularly old. This is May 20. And I guess the DeKalb case came in between. All right. Mr. Ponder, do you have questions about anything?
No, sir, Your Honor.
All right. Where is home for you? Is it Fulton, DeKalb, Daugherty County?
DeKalb.
All right. That's where you'll be going back when you get out?
Yes, sir.
All right. Well, I find there's a factual basis for your plea, that your plea is knowing and voluntary. I am going to sentence you to 2 years to serve. You said the range is 5 to 10 because it's the second?
Yes, Judge.
Okay. I'm going to sentence you to 5. I can't sentence you to just 2 years to serve. I'm going to sentence you to 5 years to serve 2, but with the balance suspended. And I'm suspending it because there's not really a point for probation to be running while you are in GDC custody. If for some reason you are paroled early, you'll be on parole out of Daugherty County beyond the end of this sentence. And so if I suspend this sentence, we don't have to weigh down Department of Community Supervision with it, but I will place as a special condition of your suspended sentence that you obey the laws of Georgia and the other 49 states, such that if you do get out before the next 3 years are up and you get arrested for something else, that would be a basis to reimpose the suspended part of your sentence. But it may well be that this case expires before you get out. We'll see what happens. So it's 5 years to serve 2, balance suspended, and you will get credit for the time you served from February 3rd, 2023. Mr. Williams, can someone from my office sign the indictment on your behalf?
Yes, sir, Your Honor. Thank you.
Ms. Dilligard?
Yes, Judge.
And Mr. Ponder, is it okay if we sign your name indicating your guilty plea in the case?
Yes, sir, Your Honor.
All right, we'll do that. Mr. Williams, anything else on behalf of Mr. Ponder?
Not at this time.
Ms. Dilligard?
Nothing further, Judge.
Okay. Well, thank you to the folks from GDC for making Mr. Ponder available. Wheeler can sign off, and we're going to turn to what's going on here in court. Thank you.
Thank you, Judge.
All right. Let's call our 1 o'clock calendar here at 2 o'clock. Position 1 is Vincent Cook. Also position 2. Hello, Ms. Wood.
Hello, Judge.
How you doing?
I'm well.
Do you have both his cases?
I do, we could come back to this one. This is another Hope House situation.
This was on a calendar almost 2 months ago. Was it to try to line something up?
It was, yes, line something up, and then I think at that point, I don't think the second case had been indicted or accused at that point. So we were waiting for it to catch up.
So it's caught up?
Yes, it's caught up. He's been referred to Hope House. Ms. Ross sent me an email this morning saying they haven't officially made their decision yet. I shared that with him. He's very eager to put the plea in and move forward. So I don't know if this is one where we should take the plea and just wait to figure out what we're doing. Or...
Well, why don't you talk with him? I'm all for assuming the state wants to go forward. We at least take the plea so he feels progress. And I can enter the finding of guilt if I accept the plea, and we'll know the basic parameters of the sentence, unless this is a blind plea where the state's recommending a bunch of time and you're trending in a different direction. And then really all that'll be left is his cooperation with Ms. Ross in lining up a program, Georgia Works, whatever it might be. So consult with him. I'm happy to do that if that makes sense. You bet. Tocorius Rose.
Judge, yes, stand up, Mr. Rose. He will be mine, Judge. I will file the waiver today, and I just need to get a good number, but I believe his address is.
Okay. Deputy Gordon, can I see you for a quick second? Are you checking on? Okay, we're good. Mr. Rose, let me look your case up. Didn't mean to wake you up there. Let's see. How'd you get notice to be in court today? You got a letter? Good. So I've got an address for you. It's coming up. An apartment on Old Hapeville Road. That's good. F16. Good. We got a good address. Your bond is from a long time ago because it's an old case. I just want to make pardon me? When was your bond?
What year did the case go
on? Well, the case is brand new. You were indicted in January of this year, but the allegation is that on September 22 of 2022, you pointed a gun at Breonna Stewart. I don't want to talk about the facts of the case or the allegations. I'm just letting you know that's what you're charged with. And you got a bond in 2023, and you're supposed to stay away from 2400 Campbellton Road. You've been staying away from there? Good. Then you're complying with your bond. And you're supposed to stay away from Breonna Stewart. You've been doing that? Okay. That's what your bond says. So we've got a good address. Ms. Wood's going to want to get a good phone number for you, and she's going to want to give you her phone number so you guys can connect. And I'll let you know when you are coming to court again. We just got to check on one other thing about you. So if you would take a seat, okay? So two things. One, yes, you can say some things. Two, if it's about your case, like I didn't point a gun or Breonna Stewart deserved it or something like that, do not say that to me right now, because sitting right there is the prosecutor. He's like, all right, the guy said he had a shotgun, not a handgun. You should talk to Ms. Wood if it's about the allegations in the case. If it's like, hey, why did this case take so long? We can talk about that if it's about process, but we shouldn't talk about substance because your lawyer might want to hear that before you blurt it out. Does that make sense? All right. So what did you want to tell me more about the facts of the case? Okay, then don't do that. Talk with Ms. Wood. I'll tell you what, talk with her, and then if she says, yeah, tell the judge that, that's great. But take a seat, not quite yet. She can come see you in a minute. So sit tight. Ms. Wood's going to talk with you. She'll let me know she's done talking. You may say, good, I still want to talk to the judge. I'll let you know when you can leave. Okay? Thank you. So you'll do the waiver, you said?
Yes.
Ms. Wood? Thank you. All right. That brings us to Kendall Fields. Hey, Mr. Fields, good morning. Do you have a lawyer?
Who's my client?
Ms. Rios?
I filed a waiver.
Great. All right, so waive and schedule. So Ms. Rios has already entered a plea of not guilty for you. The fact that you all have connected says to me she's got a good way to contact you. Is that right? Okay. What's going to happen next is that not today, but soon, the prosecutor is going to get discovery, that's police reports, stuff like that, to your lawyer so she can look at it and then talk with you about it. You all will decide whether you're filing any motions, anything like that. And then I'll see you either because there's a motion that I need to hear, like a motion to suppress, or the next time I'd see you is if you all have worked a case out. I'll be here for the plea or the dismissal, whatever the state's going to do, or your trial. We won't make you come to court for unnecessary reasons. It'll be we're working the case out, or there is a motion that we need to hear. You live in Morrow, Georgia, on Mount Zion Road? Okay, I'm gonna need you and Ms. Rios to fill out, oh, all our papers are gone. They may have gone over here. I'm gonna get you to fill out a change of address form because right now info is going to apartment 29A in Morrow. So just get your address to Ms. Rios. She'll get that filled out. And let me check one last thing. Your bond, which is also old, is pretty basic. I'm not worried about that. So you should be all set. You have any questions about anything? Okay, once you filled out that change of address form and Ms. Rios says you can go, you don't need to check back in with me, okay? All right, thank you. Gregory Adams.
He's in custody, Judge.
Okay, your case?
It is my case. I will do a waiver. I've spoken to Ms. Nix. I think there's going to be a referral to accountability courts.
Okay. Any sense of whether it's BHTC or drug court, or they figure that out?
Veterans court.
Veterans court, okay. Ms. Nix, your case?
Yes, sir.
Got it. So there'll be a waiver. We'll do a scheduling order. Obviously that'll all stop. Would this be, is it too soon to know, a diversion into Veterans Court, or would it be a plea?
It'll be diversion.
Okay. All right. Well, if you need help connecting with intake or anything like that, let me know. Otherwise, we'll get that scheduling order in place. Do you want me to engage with Mr. Adams?
I've spoken to the judge, so he's fine.
Okay. Then we'll mark that down as done. And change of address for Mr. Fields. Patrick Turner.
That's my location.
Yes, ma'am. Good seeing you. Sorry we got a late start. Mr. Turner? All right. Any sense of whether that would be a public defender case?
He did not qualify for appearance, and he would just need to apply if he wanted, so.
Got it. If and when we make contact. Bench warrant, Ms. Dilligard? All right, we'll call him one more time, but we're already an hour in. Sukasha Step. Sukasha? All right. Who represents Sukasha Step? Ms. Wood.
Will be mine, Judge. I just need to get some good contact information, and I will do a waiver today.
All right, let me look that case up. Ms. Stepp, are you at Brewer Boulevard? How about Murphy Avenue? Neither one? All right, I'm gonna need you to fill out one of those change of address forms as well with Ms. Wood, because we're sending notices to come to court to those two places, Brewer Boulevard and Murphy Avenue. So whatever your new place is, Deputy Gordon will get that form. please fill it out legibly. And let me look at your bond order. It's so small. All right, you're supposed to be staying away from a place in East Point, St. Michael Avenue. You staying away from there? I can't hear you. Okay. All right. So Ms. Wood, you'll get contact information from Ms. Stepp and make sure that change of address is filled out. And then once all that's happened, Ms. Stepp, you are free to go. You got any questions?
Yeah, what's the about that?
Yeah. Ms. Stepp, you shouldn't leave either until I give you the green light. Thank you. Nakeem Christmas.
I think he might be on the Zoom, Judge.
There's a Carlos on there.
Your Honor, Will Moran here on Lane Hammond. Carlos in the video chat is actually Lane Hammond. He just couldn't figure out how to change his screen name.
Okay, great. He's up next. So we'll get to that in a second, but we've got to try to track down Nakeem Christmas. Would that be your case, Ms. Wood?
It is my case, Judge.
Okay.
I had filed a waiver and a speedy trial demand,
Oh,
but he had wanted to be on Zoom, so
Okay.
I'm gonna try to connect.
yeah, why don't you reach out to him and let me look at speedy trial. All right. I think do you only have two? It may be that Ms. Nelson has flagged this one. I know you've got the guy who's number one on our trial calendar. Is this your only other one, or do you have a third?
I think this is my only other one for now, Judge.
All I'm asking about is for now, not encouraging anything, but you will do that. Let's see. Yep, there's the speedy trial demand. I think Ms. Nelson flagged that. So Ms. Dilligard, this should be on your radar as a fast mover. Yep, the waiver's there. Okay. Well, if Mr. Christmas joins, I'm happy to engage with him, but you already waived and we'll move on with that.
Thank you, Judge.
Speedy. All right, Lane Hammond, AKA Carlos.
Yes. Good afternoon, Your Honor. I'm sorry about the interruption on the last one, but we are entering. This is for arraignment today. We're entering a not guilty plea and waiving formal arraignment on this case.
All right. Have you already filed a waiver, or you are right now doing a verbal waiver, but you will fill out the form if I get someone to send it to you?
Well, we are verbally waiving, but if you would send me the form, we will absolutely get that filed today.
Excellent. Okay, look at that. Yep, I will have Ms. Nelson send that to you. In the waiver, there's a little place where you can check. I'm opting into discovery. I think you may have already, although the last filing in this case was from October 2023. So we'll refresh it with your opting in or not opting in. And I'll get a scheduling order out. This sets a deadline for the state to get you discovery and then for you to file motions. You don't need to worry about any motions deadline until you get that scheduling order. Mr. Hammond, the address, I got two addresses for you. I've got one in Lithonia and one in Decatur. Do you live in either place?
No, sir.
Huh. All right. Then, Mr. Moran, you've got a second form you need to fill out, and that's the change of address form so that we are getting mail to Mr. Hammond.
Yes, sir. We will absolutely do that. That may not be today. We'll probably have to have him stop by Fulton County to do that.
He doesn't need to stop, but I will have emailed to you the change of address form and the waiver. So it doesn't have to be today, but I don't want you to think Mr. Hammond needs to come by here. We'll get those things to you. If you email them back to Ms. Nelson, we'll get them in the docket. Mr. Hammond, you were given a bond in March of 2023. It's 2 years old in a few weeks. And the big condition of that is that you were to stay away from a Sharice Jackson. Have you been doing that?
Yes, sir.
Okay, keep doing that. Mr. Moran, anything else on behalf of Mr. Hammond?
No, that's it, Your Honor, and I've just asked that we be excused, and also say it's nice to be back in front of you as an attorney and not as a juror.
There you go. It's good to see you in this context. Mr. Hammond, do you have any questions about anything?
No, sir, I do not.
Your lawyer will get discovery soon from, who's handling the case for the state?
Judge, I believe that ADA Charles.
Okay.
Who's that?
She's K Charles is her name.
Okay.
Kay, and then Charles as in King. She's not in the courtroom right now, but she is the prosecutor who handles cases like this one. And she's now officially here. I saw Mr. Patrick was kind of bouncing around here.
I think it's here covering for her. He had to run down to another courtroom.
Got it. Okay. But more importantly, Mr. Moran, discovery will flow from Ms. Charles. It'll have her contact info on it. And I'll get a scheduling order out that covers all that. But you've got to get that waiver filed. So I'm going to have Ms. Nelson email that to you along with the change of address form.
Thank you very much, Your Honor. I appreciate it.
Yep. And if that's it, you and Mr. Hammond are free to go.
All right. Thank you very much. Been a pleasure. Have a good rest of your day.
All right. Take care. Daryl Carter. I'm doing all right, Mr. Carter. How are you doing? Good.
Does he, my client, I did file a waiver. Check.
So I need you to check on Mr. Carter as well. You got a busy. Mr. Carter's good? Okay. Never mind, Mr. Carter. You already filed a waiver, Ms. Rios?
Yes.
Got it. Mr. Carter, let me just look your case up and cover the same things you heard me cover with other folks. Did you get something in the mail telling you to be here?
I got a text message,
From whom?
Ms. Rios.
Oh, well, did you thank her for the text message?
Yes, but I don't know.
The address
my
is-
grandma, she didn't give me, I was in prison when, probably the court date came up.
Mhm.
And, my grandma didn't tell me, my mom told.
That's okay. The address I've got for you is in Ellenwood. You live in Ellenwood on George Washington Drive? Good. So if you stay out of prison, you'll be getting these notices because they'll go to that address. But that's on you. Your bond, also old. Let's see if it has any funky that's not the bond. Big number. You're not supposed to drive without a valid license. Hope you've been doing that, but that's also saying obey the law. So that's on you. That's it. So we've got a good address. Your lawyer's waived arraignment. She's going to get discovery soon, and then she's going to want to meet with you to talk about the case. Does she have good contact info for you? All right, then we're all set. Ms. Rios, anything else on behalf of Mr. Carter?
No, you're right.
Ms. Dilligard from the state?
Nothing further, Judge.
Ms. Rios, do you need Mr. Carter to stick around?
No.
All right, good seeing you. You're free to go.
Thank you.
Hassan Abdul
Because
in custody.
He's mine, Judge. I will do the, or I think I might have done a waiver on this one already. He has a lot going on. So we're gonna try to figure something out.
That is a boatload of PIs on the calendar.
Yes, Judge.
Okay.
And I think part of the problem is he had a few more than this and then they would get, indicted sporadically. We would resolve one and then, so
It's time to do a global resolution if we can pull that off. It
yes.
sounds like.
So I've explained all that to him and.
Are they almost all burglaries in the second? I mean, this is someone who's unfortunately hit a pattern.
Yes, they're all burglaries.
Okay, you did a waiver. You did a lot of waivers on February 18th. This was one of those waivers. All right, so you've waived. We will get a scheduling order out and then I don't know if Ms. Ross needs to get brought into the mix, but you can work with Ms. Dilligard and maybe we can get accused in one. If you're willing to agree to join some of them, we could just have one accusation rather than 6 if it's a collection of those. Ms. Rios, just so you know, I think Mr. Rose is going into custody. I don't remember if that was your case. Ms. Wood, okay.
Yes.
You knew this was coming?
Yes.
Okay. All right, and Ms. Wood, Ms. Stepp is going into custody also.
Thank you, Judge.
Okay. This is a day to get Ms. Rios as your lawyer, just in case before one. All right, so Mr. Abdul, we will move it forward, see what we can do. Amaya Harrigan. Good morning. Do you have a lawyer, Ms. Harrigan? Oh, okay. Oh, look at that. It says here, you were here in late January and you were gonna see if the finances were right for you to get a lawyer.
So that did not happen, so I just have one question.
Sure.
What are the charges?
Well, that's a great question. I'm gonna tell you what the charges are and then I'm gonna ask Ms. Rios or Ms. Wood to talk with you. They're gonna need to learn a little bit about your finances to see that you qualify. And assuming you do, then
Chief co-defendants with Tyrone Patterson, who is mine.
oh, is he on the calendar or we already did his arraignment. You got it. Okay, so a little more complicated. We're still gonna get you a lawyer, but we have to get you a lawyer who doesn't work for the public defender's office because Mr. Patterson, who's a co-defendant in your case, already has one of the public defenders. And so we get you an independent office so that your lawyer has just your interests in mind and isn't also thinking about, well, wait, what's good for Mr. Patterson? But let me answer your more fundamental question. It says what the charges are here on the paper, but it's helpful to, there's 3 defendants. Does Ms. Francis have a lawyer already? Yes, that is, it's good to know because if that's Ms. Cabrera, we have to go even, no. She has a private attorney, so she hired someone. Okay, but that's Mr. Patterson. Here you are. Okay, so your case charges you in connection and you are charged in 3 of the counts. Mr. Patterson is charged in some and you and Ms. Francis are charged in the same counts, but it relates to something that supposedly happened in June of last year. And the allegation is that you and Ms. Francis and Mr. Patterson abducted Tyson, I may be mispronouncing it, Patterson, Tysaun, Tyson Patterson, and held that person against, do you know if that's a male or a female?
That's on Soulbridge?
Says Patterson.
That's a typo. They put my.
Oh, look at that. Yeah, because it says Soldrich in another count. So yeah, that'd be a Scrivener's error. Yeah, so the name changes throughout the indictment. Tyson Soldrich is the name that's in one of the counts. Anyway, it says that you 3 falsely imprisoned this person and kidnapped the person. And then finally, you've got 1 count of battery that says you struck him multiple times, you and Ms. Francis. Those are the allegations. You need a lawyer to help you navigate this process, and we're going to get one appointed to represent you.
I'm sorry, so you said battery and.
Kidnapping, false imprisonment, and battery. All related to this Soldrich person, all supposedly occurring on June 17th of 2024. So about half a year ago, 9 months ago. Need to get you a lawyer, and that lawyer is going to need to get in touch with you. I've got an address in Kennesaw.
Question, could my mail, could it somehow go to my mom's house and I don't have my grandma's address, but that's my
Okay, you should put the most stable address you've got, a place where if mail goes there, you know you're gonna get it. If that's your mom, you should put your mom's address. If it's your grandmother's, then you need to get her info.
I'll just take the norm.
Okay, I'm gonna need you to write down on a note card, name and then phone number and email or some way so that when we line up the lawyer, and it's probably gonna be someone named Ms. Cabrera, she can reach you. So if you can, write that stuff down and give that to Deputy Gordon, then my job is to line up that lawyer for you, okay? And Ms. Dilligard, is this gonna be your case?
Yes, Judge.
Now it's out there, the indictment's a little confusing because it sounds like the victim's name didn't make it correctly into all the count. I don't know, that's a fatal error. It just was a little confusing in talking with Ms. Harrigan about that. So I don't know that you have to fix it, but it's out there. All right, so hopefully the lawyer can be in touch with you soon. I'll make sure I can read this. Is it Kemorah? Got it. All right. So we'll reach out to the lawyer. Don't worry about changing your address yet, unless you want to. You can fill. Why don't you just fill out the form right now? Oh, you don't know, but you don't know the address.
So I was asking, is it okay if I put my mom's address, because she could let someone else know, I'm not supposed to be in communication with her, so is that okay or not?
No, that's a less good plan. So let's wait. Let's wait. We'll work on getting you that lawyer, and then you can let the lawyer know, hey, we got to get a better address. But your lawyer will also get notice of every court date, and then that person will be reaching out to you saying, hey, you got to come to court. But ultimately, we got to get the right address in the system. Okay? Any questions about anything? All right. We'll see you soon. Branyon Ingram. Boy, the bail project got him out. Is that your case, Ms. Wood?
It will be, Judge. We can find him.
Why is it on? I'm confused as to why this is on for Plea. It's a 23 SC case.
Great question. It might be a repeat, well, yeah, repeat offender.
Meaning like it just now is coming from our friends in non-complex? 189.
Yes, it was transferred February 11th.
Come on.
Repeat offender.
Okay. Here it is. All right. But he's not here. So unfortunately for him, that will be a bench warrant for now. If he makes contact with you, we can always walk him in. Oops. Wrong pen. Ethan Brown.
Judge, I filed a waiver and I believe he was excused by Ms. Nelson.
I think that's right. I remember her flagging this. So waive and schedule. Okay. Brandon Chavis. Good morning, sir. Do you have a lawyer? Okay. This is a co-defendant of Mr. Brown, so it's not going to be the, oh, it looks like a conflict defender represented you at one point. Let's take a look. All right, so Ethan Brown got this case to us. How'd you know to come to court today? Got a letter. Oakland Drive? Okay. We need to handle your situation just like Ms. Harrigan, young lady who just left. I need to make contact with the conflict defender's office. I'm assuming you would like a lawyer appointed to represent you. You're not gonna be hiring one. Okay. Then I need you to do the note card exercise where you put down your name, a good phone number, and an email address so that when we line up that lawyer is able to reach you, okay? All right. Deputy Gordon will get you that note card, and then we'll figure out another time to get you here, and you'll get something in the mail to that Oakland Drive address. All right, and then the only other thing I had was Ricky Pierce, which we'll deal with in a minute. That is a Ferretta hearing. But you're here, Mr. Hiles, and we got a defense attorney here. I don't have another calendar. What did I miss?
There's an add-on calendar for Quintavious Jackson.
Oh, I remember Quintavious Jackson. I don't.
For the plea judge from the probation revocation.
Yep. I just don't know that maybe that didn't make it onto the collection of calendars here. Yeah, I don't have that, but doesn't mean we can't do it. Is that ready to go?
Ready to go?
Okay. Pardon me?
I was gonna ease upstairs.
Great. So we'll do that. Before we do that, Ms. Wood, I'm just circling back on the calendar. You want to talk with Mr. Cook? Because you've been stuck out here. Well,
I will speak with him.
you'll talk with Mr. Cook. Mr. Rose went into custody. Thank you. But it's a waiver and scheduling order. And Mr. Fields, is he still here?
No, I had already filed his change of address.
Good. Okay. Patrick Turner, still a bench warrant. All right, Mr. Chavis, let me make sure I can read this. The first word is pain on the email address. What do you do for a living? Renovation? Okay. All right, well, good. You hopefully will be contacted by a lawyer soon, okay? All right, you're good to go. So Patrick Turner is a bench warrant. Ms. Stepp went into custody, but that's a waiver and scheduling order. Mr. Christmas is a speedy, but we took care of that. Needs a C3. Last call for Branyan Ingram. And then Mr. Chavis needs C3. All right. Then I think we can do the Jackson plea. And Ms. Wood, you can talk with you. We have a lot of folks here. What case?
To the add-on calendar. I don't know if you know.
There's another add-on?
Yes, Christopher Shanks.
Yeah. The case of last week.
Okay.
But they're.
Oh, wait, Ms. Nelson brought me all these pieces of paper. Okay, yeah, Shanks is there too. What are we doing with Mr. Shanks?
Patrick there were some issues with the accusation. He thought it was.
Oh, right. This is the one where, aren't there like a bunch of other cases he's gonna resolve?
He thought it was what was on his message, and he said they were all accused this morning, but then now they're saying again, I need waivers, and going to the clerk's office and figuring it out now. So hopefully by the time this plea's done, it's all been figured out.
Yeah, he needs to fix that. He had a chance to tell you what you needed before.
That's just definitely, he said he said it was done, but I think, I'm not gonna blame him.
I am.
There's something else going, I don't know, but.
Okay.
And he'll be back.
Got it. We'll do Mr. Jackson then. That'll give us more time to do Shanks, and we can always turn to Mr. Pierce, and that'll give us a lot of time to wait on Shanks, and we can take Cook whenever Cook's ready.
Yes, sir. I just wanted to let you know, there's a couple of people here that the bonding companies told them to be here. I think it's because of a motions date from a scheduling order.
Oh.
And I didn't have a motion, so I know
Okay.
Mr. Roger Plea is here and Mr. Nickerson was here. So I just wanted to let you know.
Give him credit for being here. Excellent. And so future reference, if the bonding company says, hey, you need to come to court, always check with your lawyer too. Don't ignore the bonding company because they'll come get you. But check with your lawyer as well. And Ms. Wood, Ms. Rios, whomever will be able to say, oh yeah, here's why they're saying that. You don't need to come to court. So if you were here today because the bonding company said you need to be here, you're good to go. Appreciate you being here. All right. Even wore a tie. So we're ready for Jackson when you're ready.
Judge, you want us to the podium?
At the podium, please.
Good to see you.
You see, so good.
Family's here. Your family's here. Your family.
Oh.
We're just.
Debbie, what do you want? Yours back? You always get the big paper.
Same thing.
You ready, Mr. Haas?
Yes.
All right. Mr. Bixson, you guys ready?
We are ready, Judge.
All right, let's go on the record in State versus Jackson. It's 25 SC 000605. And I'm going to let either Mr. Hiles or Mr. Bixson provide the overall procedural framework, but I know at a minimum, one thing we're doing today is taking a plea, Mr. Jackson, on this new charge, which relates to possessive firearm and possession of tools for commission of a crime. But I know you had some revocations as well, and I may not have finalized those because we were going to handle this today. I just want to make sure that when you leave here today, we've taken care of all your business. So that if there was a revocation, we dealt with that. Obviously, there's this plea. If before we dive into the plea colloquy, one or both of you could lay the setting, we'll go forward.
I can, Judge. So we were back here last, I think in January for a probation violation on 18 SC 162 228, as well as 22 SC 185 166. That indictment and accusation were consolidated for purposes of trial, and he took a plea to that, both of those, and was granted first offender. The basis of that revocation filing is the accusation we are here for today. And so my recommendation was, because it gets confusing with time served in the revoking first offender and then entering sentence, was that the first offender be revoked on both of his cases that we were present for probation violations, and that if he waive indictment, I would accuse this case, and my recommendation is 10 years to serve 3 years with the balance on probation. And I agreed with Mr. Bixson, after going back and forth, that he would make his argument for whatever the sentence should be on this new case, and I agreed that it would be the state's, the state would agree to run those, whatever you decide, be the sentence for both revocation and the new case.
Okay, but if I were following the state's recommendation, then what I'm doing is, and I accept the plea, is sentencing Mr. Jackson to 10 to serve 3 on what I'm calling the new case, but also entering an adjudication of guilt in the two older cases for something that would be no more time than that. In fact, I could say a year to serve on both those, credit for time served, and those sort of get consumed by the sentence in the new case.
That would be, yes.
Okay, and that's not inconsistent, not that I'm following the state's recommendation, but that wouldn't be inconsistent with the structure you have in mind.
No, it
Okay.
wouldn't be inconsistent. It was, I was recommending a 3 years to serve was essentially the recommendation, but when you deal with the calculating time for, what you get credit for on a first offender revocation, it gets gone.
Okay, well, I'll look at the older cases while we're working through the colloquy. Mr. Bixon, do you agree that that's sort of the framework we're approaching? Not the 10 serve 3,
Yes.
but we're going to be revoking first offender on 2 cases, which requires me to do an adjudication of guilt on both those cases. We have a new case, there'll be a sentencing for that, and then you're going to be advocating presumably for something less than 3 years to serve.
Correct. Yes.
Okay, then I think we're in the same space. Most importantly, Mr. Jackson, do you understand what we're doing today?
Yes, sir.
Good. In just a moment, Mr. Hiles is going to put you under oath. Once you're under oath, you need to answer his questions truthfully and completely. Let me know, please, if you've got any questions of your own. Mostly the questions are going to be coming at you. But if at any point you're confused by something or like, just wait a minute, I don't get what's going on, let me know. It may be you and Mr. Bixon speak privately. It could be just as a group, we sort it out. Will you do that?
Yes, sir.
All right, Mr. Hiles?
Yes, Mr. Jackson, will you please raise your right hand unless you're voting? Do you swear or affirm that the testimony you shall give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth, under subjection to perjury?
I do.
That's got to be the weirdest oath I've ever heard. It covered what it needed to. You can put your hand down. It just means you're going to tell the truth.
Quit from reading. I was reading an admin language. All right, you can put your hands down. Please state your true, correct, and legal name.
Quintavia Jackson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take or have not taken today?
Yes.
All right, without saying what that medication is, does not having taken that medication affect your ability to understand the proceedings today?
No.
How old are you and how far have you gone to school?
25. I have a GED.
Are you able to read, write, and understand English language?
Yes.
Do you understand that in accusation 25 SC 000605?
I got to just interrupt real briefly. I thought this was my case. This has been assigned to Judge Krause. Someone has I'll manage Judge Krause, but the prosecutor there, no, it's Mr. Bixon's, but technically has a public defender in Judge Krause's courtroom assigned to it. But
Yes, it was supposed to be green sheeted to your courtroom. It was agreed upon that it was going to come to this courtroom.
we all did. When you go into Odyssey, it says Judge Krause, it says Jennifer Colangelo, who's the public defender in that courtroom. But if Mr. Bixon is representing Mr. Jackson in connection with this, that's all good. And I'll manage Judge Krause. Should be happy that it's
I'm sure Judge Cross would be happy that one less case.
right. I don't get credit for it, but that's all right. Okay, good to know.
And so do you understand that in accusation 25 SC 000605, you're charged of 1 count of possession of a firearm by a first offender probationer and 1 count of possession of tools for the commission of a crime?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you gone over the rights that you were waiving today by entering a guilty plea with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bixon, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with your attorney's services?
Yes.
Mr. Bixson, do you waive formal reading of this accusation?
We do.
Mr. Bixson, for the purposes of this plea, do you waive any and all defects in this accusation, including any with respect to your client's name?
We do.
Mr. Jackson, have you been advised of the minimum and maximum sentence for each charge you're pleading guilty to today?
Yes.
And do you understand that the sentence range for the possession of a firearm by a first offender is 1 to 10 years?
Yes.
And do you understand that the sentence range for possession of tools for the commission of a crime is 1 to 5 years?
Yes.
Do you understand that the judge does not have to accept the sentence recommendation of the state, nor the sentence recommendation of your defense attorney, and he can sentence you up to the maximum of each charge and run those charges consecutive or one after another?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including those in federal courts? Do you understand?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Do you understand that as of entering this guilty plea, you will now be a convicted felon, and that you may not possess or transport a firearm unless and until your rights have been fully restored? Do you understand?
Yes.
Mr. Jackson, are you a United States citizen?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you'd have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not incriminate yourself? Do you understand?
Yes.
All right. I'm going to go through these next rights that you're waiving one at a time. Do you understand that by pleading guilty, you're giving up the right to trial by jury?
Yes.
Do you understand that by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the right to confront witnesses called to testify against you?
Yes.
Do you understand that by pleading guilty, you're giving up the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand by pleading guilty, you're giving up the right to the presumption of innocence?
Yes.
Do you understand by pleading guilty, you're giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that by pleading guilty, you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that by pleading guilty, you are giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes.
And do you understand that by pleading guilty, you're giving up the right to appeal if convicted of these charges after a trial? Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of possession of a firearm by a first offender probationer, as well as possession of a tool, as well as possession of tools for the commission of a crime?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and or constitutionality of this guilty plea?
Yes.
And do you understand that you are have only until the end of this current term of court to file a motion to withdraw this guilty plea?
Yes.
Your Honor, were this case to go to trial, the facts would show that on March 13th of 2024, Officer Schaefer of the Atlanta Police Department was behind a Range Rover driven by the defendant in this case. There was a vanity plate affixed to that Range Rover. I believe that was registered in the state of Indiana. Or it was either Indiana or Illinois. I can't remember off the top of my head. When the plate was run by the officer behind it, there was no hits to it. It didn't come back as registered to anything. So the Officer Schaefer then conducted a stop of the car. Mr. Jackson pulled the car off the side of the road and into a mechanic shop, in which time Officer Schaefer, when he approached to get the ID of the defendant, he smelt the odor of raw marijuana. During this process, it took a while for the officer to figure out who the car was registered to and what happened, or why the tag wasn't returning to registered as anybody. It turns out there's a special process that you have to go through for a vanity tag out of that state that is not just your standard NCIC or GCIC registration request. And so at the time, it didn't turn out as valid. Now, the body camera from this interaction shows that Mr. Jackson is wearing some sort of lightweight black jacket. During the encounter, Mr. Jackson asked the officer, "May I take my jacket off?" He takes his jacket off and drapes it across the floor of the passenger seat of the car, for which the officer standing at the window would not have been able to see what was on the floorboard at that time. Officer Gordon then arrives and the car, and I should say that Mr. Jackson is detained while all this information is trying to be figured out for officer safety, but the car was searched and so because of the smell of raw marijuana. There was raw marijuana discovered inside of the center console that wasn't charged. It was misdemeanor amounts. However, when Officer Gordon went around the car, you could see that the rifle, there was a 5.56 Diamondback rifle that was on the ground of the passenger floorboard. The jacket had been draped and wrapped around that rifle. Additionally, from the glove compartment, there was recovered a window punch, a long screwdriver, and the rubber gloves with they're leather gloves with thick rubber bottoms that are commonly associated with the individuals who are shattering windows in cars to prevent cuts. Your Honor, the offer in this case, I know it is a possession of a firearm by a convicted felon charge, but it also stems from what was offered in the deal given to the defendant in his two previous cases that are the basis of the revocation. The defendant is an admitted member of the 27 Unos criminal street gang. They are known for auto thefts, entering autos being the primary moneymaker, especially the thefts of Range Rovers. And
Did this Range Rover, it was from Illinois, the vanity tag was from Illinois, it said Kobe. Did this Range Rover come back stolen?
No, he was in lawful possession of the Range Rover.
As far as we know, it just didn't come back stolen.
They were able, no, it didn't. They actually were able to get in touch with the owner of the car.
Oh, who said, yeah, Quintavious should be driving my
Yep, and then
Kobe
that's how they
mobile.
were able to figure out eventually how they needed to get the plates run.
Okay.
Yeah, so the 22 SC 185166 indictment, that was actually 5 separate incidents that were combined into an accusation to allow the defendant to essentially utilize his first offender status along with the 18 SC case.
Well, there's also a 20 SC case that he pled to at the same time.
Yes.
So he got a 3 for, but really it sounds like it was more like an 8 or 9 for, because the 22 SC was this agglomeration of stolen car, stolen car, stolen car. Okay. And he got a 10 serve 3 first offender.
Yes.
And yet a year-ish later, here he is, rifle, tools for commit a crime.
And the 18 SC indictment, several gang charges. There were the most serious charge of possession of trafficking in heroin dismissed from the house that he was arrested in. I'll be quite frank, that case, that charge was dismissed more so because of equal access to everyone in the house, but it was still part of the original negotiations. Also too, the thefts, I should add that there was a face mask recovered, full face mask recovered in the defendant's jacket. So that's the basis.
The jacket that was put over the rifle in the Illinois Range Rover.
Correct.
Okay.
So that's the basis. I think we feel the revocation of the first offender status, along with an additional sentence of 10 years to serve 3 years, is absolutely more than fair. And would ask that you follow the state's recommendation.
2 questions. One, anyone else in the Illinois Range Rover?
No, he was occupied the car by himself.
Okay. 2, this is the same offer that, I don't know if it was you, whoever handled the cases in front of me back in November of 2022 that Mr. Jackson got. So why not more? He got 10 to serve 3 then, and then this happened. So I'm just curious why a sanction that didn't appear to deter Mr. Jackson, you think is a sufficient sanction this time?
I honored the offer that had been extended as of last time.
Okay, I'm not criticizing. I'm just working through the thought process.
I think that, well, it's really just gauging it based off of other offers made to similar situated defendants.
That's a good barometer to use.
And especially around this time. And so that was the basis of it. I did feel that another 3 years of incarceration is appropriate. Additionally, too, now if he is arrested for any additional felonies, he will be an A and C recidivist offender. And he will be facing substantially harsher punishment requirements should he commit any future felonies.
He will have graduated. All right. Let me look up this 20 SC case that we haven't been talking about. I'm doing that only because it got null prost. I wonder why it was running concurrent with, but okay. It's not even have his name on it. Maybe it was a typo on the final disposition in the 22 SC case lists a 20 SC case, but that's not, we don't need to worry about it. That's not his. Okay. Almost to you, Mr. Bixon. Ms. Jackson, do you have any criminal history information on Mr. Jackson?
He has 6 cycles. The last arrest was October the 16th, 2020 in Sandy Springs, Georgia, for entering an automobile. That charge was dismissed on March the 23rd, 2023. He does appear to be on first offender probation. That case number is 18 SC 162228. for possession of marijuana with the intent to distribute. That disposition date was August the 30th, 2022, and the term is for 5 years. Nothing in addition, Your Honor.
All right, thank you. Mr. Bixson.
Yes, Your Honor. This is Mr. Quintavious Jackson. He is here before you today to plead guilty, to accept fault and responsibility for what he has done. I don't think that's ever easy at 24. It's certainly not any easier. I want to thank Mr. Jackson's family for coming on in today. If y'all could stand up. Thank you. Judge, I said it last time we were here, but his family has been behind him this whole time.
About to be another member of the Jackson family. Let's keep her seated there. Okay.
But Judge, they've been great. They have fully supported Quintavious throughout this entire process. They've been at all his hearings. They've stayed in constant communication with me. And I found for anybody going through the criminal justice system, that is vital to making sure that you make it out and you don't go back in. Because if you don't have a strong support system, you are almost guaranteed to go back. Last time we were here, Judge, if you recall, I was asking for a 90 to 120 day PDC in lieu of the 10-serve-3 the state was asking for. And I'll just be real straight with you, Judge. Anything less than 3 is a gift to Mr. Jackson, because I think the reality is, and I spoke about this last time, if Mr. Jackson goes back into the DOC, there is a very real chance that he will not be making it out by that 3-year mark. I don't think he'll ever make it out. As evidenced, and you can see it on his face, what happened to him last time he was in the DOC, Judge. He was heavily victimized. He was cut. He was stabbed. And I don't think that if he goes back in, he's going to be coming back out. He's been in custody here in the Fulton County Jail for about 5 months now. I think sometimes it takes a good kick to the head to understand what you have on the line. I think 5 months in the Fulton County Jail is like getting kicked in the head repeatedly. So I think that certainly sent a strong message. But even that being the time that he served there, we're still asking for more, Judge. And like I said before, we are asking for that 90 to 120 days PDC. I think roughly by the time that he gets over there, by the time that he gets out, he'll have served almost about a year, is my guess. The biggest difference is he's much less likely to get stabbed in PDC than he is in the DOC. And that's my real goal. And in all honesty, Judge, the reason why I say the PDC is because it's the only other thing I can think of aside from the Fulton County Jail that would be straight time in custody where he wouldn't be have that chance of being attacked. So with that being said, Judge, we would ask for that sentence of the 90 to 120 days. You give him as much probation as you want, 10 years, Judge. We're totally fine with that. It's just where he's going to be serving the time and how long it's going to be, I think, is our main concern.
Okay. Is there something about Mr. Jackson that you think has made him susceptible to being attacked in GDC?
I'm sure
not that it's a safe place and a happy place, but I don't know, is it 27 Unos? Is it his attitude? He's a Dodgers fan?
I'm sure that it has to do with his past affiliations.
Okay. All right. Mr. Jackson, do you have any kids?
No, sir.
Anything you want to add to what Mr. Bixson had to say?
No, sir.
Okay. All right. Well, Mr. Jackson, I find there is a factual basis for your plea to this most recent situation where the rifle and these other things were in the Range Rover from Illinois. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Voluntary means no one's forcing you to enter the plea. Do you agree with both those?
Yes, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act, which means what it meant last time I sentenced you in cases, which is that while you're on probation, if you have a minor violation, not getting arrested for something new, but you miss a meeting or maybe you test positive for marijuana or something, probation will work with you on that. You don't have to come back and see me. But if you get arrested for something new, that comes back to me and usually has more serious consequences. So a few things. One, if prior time in different facilities were going to change your behavior, I make the following observations. You spent over 750 days at Rice Street in the past on one of these cases. So if Rice Street was going to get you heading in a different way, we wouldn't have this case. You also spent some time down the road, and yet when you were out, you got pulled over with all that was going on in that car. And what I'm going to say makes it sound much easier than it is. I don't mean to suggest that you can flip a switch and then you're able to go get a job or stay away from folks who maybe pull you in the wrong direction. But I take to heart some of what Mr. Bixson had to say, which is there are folks who care about you, they're here, and they are here for you, but you need to meet them somewhere. They can't sit on your shoulder 24/7. And so when you are next out, hopefully you'll be keeping them in mind when you're deciding, am I going to head in the direction where if I get pulled over, I'm driving an old beater and all that's in there is my lunchbox because I'm off to UPS to work a factory job. Or when I get pulled over, is it going to be a car that's a magnet for officers and they got to spend a long time figuring out, is it a hot ride or not? And by the way, there's a rifle and there's the gear that I used to use in my other cases when I was breaking into cars. You don't demonstrate that you were doing anything new and different, despite these folks who care about you. But it's not me lecturing. It is not me saying it's easy to do something new and different. It's me saying you're going to need to figure out how to do that because each time you go back in, it's going to be longer and longer. I'm not going to exceed the state's recommendation, but you heard me poke at Mr. Howes a little bit like 10 serve 3, he did that last time. And yet here he is just a few months later and he's back doing the same thing. It clearly didn't discourage him from doing that kind of stuff. So I'm hoping that as you get older, with that comes some wisdom and some willingness to just move forward in life in a different way. And it may be humbling at first. It means, man, I got to go flip burgers, or I'm going to go work at the Amazon warehouse. And that's not as flashy as driving the Kobe 4WS Range Rover, but it's going to keep you out of jail. That's a decision for you to make, not for me to make. So Mr. Jackson, as a result of all of this, follow me as we walk through this. In 25 SC 000605, on count 1, I'm sentencing you to 10 years to serve 3 years. That's going to sound familiar. It's what you got last time, with the balance on probation. You'll get credit for the 114 days that you've been in custody in connection with this case. You were in for about 5 days when you first got arrested, then you bonded out, and then you've been back in. It's not quite 5 months yet, but you've been in since the middle of November of last year when you got picked up, I think, on the probation warrants. But either way, that was when you were last in custody. You'll get credit for all of that. Count 2 will be 3 years to serve. That'll run concurrently, same time as count 1. I am revoking your first offender status and resentencing you, entering an adjudication of guilt. We'll start with the oldest case first, 18 SC 162228. And in that case, count 1 had been dismissed. Counts 2 through 6 were all gang cases. And your sentence in that for those counts is all 5 years to serve 3 years. With the balance suspended, 5 years to serve 3 years with the balance suspended. And count 9 is, it has to be, it doesn't. That's going to be 5 years to serve 3 years as well with the balance suspended. Those will all run concurrently with each other. Counts 10 through 13 all have to run consecutive. Count 10 runs consecutive to count 2. It's 5 years suspended. And then 11, 12, and 13 are all 5 years to serve suspended, concurrent with count 10. And then count 15 and 16 are both 12 months to serve, concurrent with count 2. So your total sentence in 18 SC 162228 is 10 years to serve 3 years, but with the balance suspended, no probation there. It will be a special condition of your probation that you, of your suspended sentence, that you obey the laws of Georgia and of the 50 states. So you're not going to be supervised in that case, but if you get arrested for something new, the state could come back and reimpose some of the other 7 years in that case. In 22 SC 185166, your sentence as to count 1 is 3 years to serve. Count 2 is, let me make sure there's not a gun charge in there. There's not. 10 years to serve 3, balance suspended. Count 3 is 3 years to serve. Count 4, 10 years to serve 3, balance suspended. Count 5, 3 years to serve. Count 6, 10 years to serve 3, balance suspended. 7, 3 years to serve. 8, 10 years to serve 3, balance suspended. 9, 3 years to serve. And 10 is again 10 years to serve 3, balance suspended. All those counts run concurrently with each other. So the total sentence there is just like in your other older case, 10 years to serve 3 years with the balance suspended. The only condition of your suspended sentence is that you obey the laws of Georgia and the 50 states. You will get credit for all the time you've ever served in those other cases, which is going to be a whole lot more than the 114 days you've served. So these aren't extending your time in custody at all. I can't do the math, but the state has to give you credit for any day you served in custody in either of those cases because you already had a sentence for those. I'm just resentencing you, but now as a felon rather than as a first offender. You may have said this and I'm not remembering it. You may not have said it. Mr. Hiles, special conditions of probation in the new case. One would be that he forfeits anything and everything that was seized in connection with his arrest in March of 2024.
For the gang counts, the special conditions statutorily, it's.
Well, there aren't gang counts anymore. Those are suspended sentences. So the only probation he's going to have is for the new case.
I know.
Oh, okay.
But I think even with the suspended sentence, it's still required that, based on the statute, that they have no contact with gang members, and no participation in criminal street gang activity, and no contact with listed victims.
Okay, we'll make that a condition of his suspended sentences for his active probated sentence that he will serve when he completes the remainder of his custodial time.
Possession of no weapons or replicas. No
Okay.
Future violations of the law.
Okay, that's all covered. Anything else from the state?
No, Your Honor.
Mr. Bixson, anything else on behalf of Mr. Jackson?
Nothing from the defense, Judge.
Okay, Mr. Jackson, any questions about anything?
No, sir.
Ms. Simpson, reporting instructions will be within 48 hours of release. Okay, so Mr. Bixson will be able to counsel you more on when you might be paroled, how that would work. He doesn't have a crystal ball, but he can talk to you about the likelihood of that. When you are released, you've got 48 hours to report to probation. And ideally you do that, the one here in Fulton County, but it really is driven by the county of your residence. So when you get out, if you're living in DeKalb, then you would report to the office that's in DeKalb County. Okay?
Yes, sir.
All right. Thank you, everyone.
Thank you, Judge.
You may. You bet. Ms. Wood, what's happening with Mr. Cook?
Judge, I was unable to go back there while we have,
Oh, okay.
but,
We have to take a break anyway because Ms. Rivers is taking a break. But what else did you want to add?
I was gonna say, I was thinking back there, while Bruce back there, so.
Okay, is she talking to Mr. Shanks? Mr. Patrick, are we able to go forward with Mr. Shanks? Answer should be yes.
We should be, Judge.
Okay,
So Ms. Rios knows all of this. Apparently Thursday, after I drafted the accusations, the sheriff's office realized that they had not attached the right warrants to the right cases. And so my accusations couldn't be filed because the clerk was seeing something that was not there.
Okay,
It,
so it really was beyond your control, because Ms. Rios was defending you. I was not defending you, because she was saying, I have to file another waiver, and I said, you don't have to file anything. Patrick needs to get this stuff done. But it sounds like if the sheriff had misconnected things, we were stuck.
yes, Judge, and then I was actually considering coming to you and asking for you to just order, but what, take the file.
Yay.
Here you go. So in an abundance of caution, we're filing paper copies of everything.
Okay.
I am told that everything is done, but they told that.
Okay. So we have other things we can do, so we should hold off a little bit on Shanks.
If we could do that, the head legal assistant is from our office, is going to be coming and bringing me case numbers when the clerk is happy with what is on what piece of paper and what box is checked.
Okay. Do you miss your former county now?
You know what, Judge? I do.
Yeah. It's all right. We have a large volume of stuff, and sometimes there are hiccups in certain corners of the operations. So we'll come back to Mr. Shanks. We're finding out about Mr. Cook. I guess we could do, what would you like to do? Oh, you were looking like, hey, can we take care of this one thing and get the heck out of here? No? Should we do Pierce?
Yes.
That's not gonna be easy, but we can do it. All right. I'll be right back and we'll do Mr. Pierce. You ready for him? Okay.
Sure was tired. Which one? I'll take him.
Who?
Yeah.
All the witnesses that he ordered.
Yeah. I'll take him.
Yes.
You're willing to get.
Well, the day they, knowing that.
Yeah, he like thinks he's not done bad. Yeah, no, like.
I was trying that case.
Probably me.
I mean, like, they.
Well, I'm hoping. I think. Won't make you feel the same. It's just you here. And then we can talk with there. Or whatever it's called. Fool. I'm fool, right? Yeah, let's just let him say. Get people in custody. It's dangerous in jail.
You just can't believe that, right?
Be quick first. I learned I was stupid. It was crazy.
You can't do that.
Oh, wow. Now I just give it. And I start lying. That's what I did.
So, I 4 times in the last 6 days. Every time I went, they would tell me one thing. Like, oh, this needs to be filed down. Okay, so I go find somebody to file it down. I don't know how to do it. And the law is so then I take it.
It's so easy once you learn.
Thank you. And I take it. And it's like I get an email in an hour and a half. So they go, I need to put something wrong.
Right.
So I come in. So I come back.
They like their heads are big fun. And they know we're always in a rush. So it makes people feel like they're rushed.
Oh.
Just fun.
Well, I mean,
Everywhere else is other person.
But if he doesn't.
Like I would look at it. But here, Bill Miles and yeah.
but they can reject it.
Legally sound.
Well,
Or I mean, like the case of
yeah, yeah, they can,
Lito.
shut up. But they're supposed to put it in whatever case number.
Yes.
If it-
They don't do that here, but they can't. They move around. They won't do it. So, but yeah, it's a battle. Mhm. I know. I know. It's a hard one. I have to think. Oh, we've been up since four. Yeah.
And so, just have a piece of paper.
It doesn't get better.
They want.
What do you want?
Just shut up. Just shut up.
You got the email from Ms. Simpson about, and I'm happy having that hearing, and it may make a ton of sense. You just may have to dredge up victim info or whatever. Did you must, I think that, I never know how they get delivered to your office. I'd get them after 30 days have passed. Ms. Simpson gets from the probation officer, hey, the DA's had more than 30 days to bless or oppose this early termination of probation. Now send it to the judge. And the memo says that we got no input from the DA. I'll look at it. And if it's one where there's not a victim, I'll usually sign it. If there is a victim, what I had been doing was sending it to the line ADA, but we've since had the conversation and you said, send it to me. But you need to be getting it before I get it, because if I get it, you've missed the 30-day mark and then we have to have a full-blown hearing.
I sent you one, either this morning or yesterday.
On average, how many of these do you think it's?
I don't did a lot.
It's infrequent.
Gotcha.
So you may want to unvolunteer, but we just need a process, because if it's a victim crime, like this one, and when I looked at it, like, I'm not comfortable doing it looks like the guy got a great deal. And I don't want it to be I want it to be an affirmative waiver from the DA's office. And I worry that it got stuck in an inbox and no one messed around with it. And I don't mean Ms. Dilligard. I don't think it goes directly to the line aide. It wasn't her case. I don't know where it goes.
I mean, for now, I don't think we have a process, which is, I think for now, just be me.
You're the process, you and Embiid.
Until notified of.
Now, there's a section at the bottom of that, of the petition that says if you want to check, there's a section where you can check it off. and
Just
say,
say,
Yeah, I'm not agreeing to this nomination, and then that's what you don't have to refer to public hearing.
All right, I didn't mean for us to get distracted by that, but we had all the right folks here. Ms. Wood?
Yes, Judge. So if we can bring Mr. Cook out, he's not happy. I think he wants to do a plea, but I've explained to him what we're waiting on, and he's just not happy with me right now.
Well, I was gonna handle Mr. Pierce next. Okay, so we're gonna do that. I just want to get the case up on my screen, and then we'll work through Mr. Pierce, then we can turn to Mr. Cook.
Thank you, Judge.
Sure.
You want that podium or?
Yeah, probably the podium. I think that's gonna be easier. I just need to find my checklist. Give me 1 second. Here it is. All right, I'm ready when they're ready. Good afternoon, Mr. Pierce.
Good afternoon.
How are you?
Fine, and you?
Good. I'm hanging in there. It's been a long day, but I'm sure it's been a long day for you as well. Whoop. Let's get your stuff all situated.
Y'all sit down, man. Y'all sit down.
Okay, well, you've waved to him, but this isn't a place where we have that kind of conversation. You bet. Mr. Pierce, when we were last together, we had a conversation about representation, and you told me that you wanted to represent yourself. You didn't want a lawyer appointed, and you weren't going to be hiring a lawyer. And I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda so we can see if there's anything else.
I'm American State National, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I wanted to address. You said you were going to let me hear me. You're going to let me address all my issues last time I was here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay, but if we're going to do that, we have to have my conversation first. I'm required by law and by the Constitution to go through a few things to make sure it's appropriate for you to represent yourself. So you can want to do it, but I got to make sure it's appropriate to let you do it. I'll just give you an example. Let's say that you were deaf. That might make self-representation kind of complicated. You're not deaf, and so you can hear me and I can hear you, but I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it and getting all those things you want to represent yourself, I have to give you that right, and I will, and then you can share with me what your issues are, okay? You ready to work it that way?
Yes, sir.
Excellent. Let me get one thing here and we can get started. All right, Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED?
Yes, sir.
When did you get your GED?
2017.
Excellent. Are you able to read English?
Yes, sir.
I know you can write in English because I got these and you actually mailed me something that
Yeah, I wrote you a letter.
about 200 pages long. All right, so you can read and write and you can speak English. Have you ever worked before?
Yes, I had several jobs.
Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked there for Airmark. I worked there for the Move State in North Carolina. I have my own landscaping business. I have my own record label. I worked at McDonald's, Burger King.
You've had a bunch of jobs. Got it. All right, that's helpful to know. I appreciate you sharing that. Have you gone to law school?
I haven't gone to law school, but I have practiced, not practiced, I've been studying law.
You've been studying the law. Tell me how you've studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Okay. Got it. Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you've watched one then?
Yes.
Okay. What was that trial about?
Armed robbery, the 10 years I just did for armed robbery.
So you were charged with armed robbery.
Yeah.
And that case went to trial.
Yes, sir.
So you were there from jury selection all the way through verdict.
To closing argument. I stopped before closing arguments and took 10 years.
Oh, you pled guilty.
Yeah, I
Got it.
tried right before they were finna come out for closing argument.
So you've seen 95% of a trial.
Yes, sir.
All right. You ever watched a trial on TV?
Yes, sir.
What kind of trial?
What that movie that's so called? Law and Order.
Okay, you've seen that kind of stuff. So you've seen the made for TV stuff.
Right.
But you've been in a real one. You were a participant in a real trial.
Yes, sir.
How long ago was that trial?
2016.
Where?
Here.
Fulton County.
Yes, sir.
Who was your lawyer?
Kevin Farm. He's a judge now.
He is. That's a small world.
Yeah.
All right. Have you ever represented yourself in a criminal or a civil case before?
No, I haven't.
This would be your first time.
Yes, sir.
Got it. Have you ever gone to a doctor or a counselor to get treatment for any mental health issue?
No, sir.
Depression or bipolar or anything?
No, sir.
Okay. Tell me why you think you would do a better job representing yourself than a trained lawyer who went to law school and has done trials before would do.
Because by me being a Mr. National, a lawyer only subject me to the jurisdiction.
So hold on 1 second. Yeah, you got it. So the court reporter needs to be able to take down what you're saying. What you're saying is important. So just don't rattle the change, and then she'll be better able to hear you. So you were telling me by being an American
State national, and by me being a national, I can't be represented by an attorney because attorney automatically subject me to the court's jurisdiction.
Okay. So my question was a little different. I hear you. But my question is, why do you think you would do a better job than a lawyer? It sounds like you may think a lawyer would do a better job, but you don't want a lawyer because you're worried that would subject you to the jurisdiction of this court.
I know for a fact it will subject me to because a lawyer is as an officer of the court, and by them being an officer of the court, it automatically subject me to the court's jurisdiction.
Okay. Well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you say, Judge, you're wrong. Okay. But I get to make the decision initially. And then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I've decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer because you're stuck here anyway? Or you still want to represent yourself?
I still want to represent myself because I'm not under the court jurisdiction.
No chains.
Okay, my bad. My apologies. I'm not under the court jurisdiction, and I've been studying it long enough. Almost my whole family is nationals, and we know pretty much a lot about it. And we know for a fact the only way I could be subjected to a court jurisdiction is through a lawyer, because the birth certificate is a void contract, and through that contract, the birth certificate contract is what makes me subjected to the court jurisdiction.
Okay. I'm going to stop you again, not because I'm disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes a jury. We're going to do the trial. And so we'll go through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and I will fix it. But there'll be this trial. You're going to want to represent yourself, even though we're going forward with it.
Yes.
Okay. Do you know what you're charged with in the indictment?
No, I haven't had. I know what I'm charged, but I haven't had nobody come talk to me about nothing. I don't know what's going on. I don't know.
Well, that's because you've said you don't want a lawyer. And so this is what we're getting into. No one's going to come talk to you about what's going on. I'll make sure you get the discovery, the paperwork in the case.
And when would I? When
Well, it's complicated. We can get you the paper stuff pretty soon.
Okay.
But if I'm making this up, I don't know what's in the case. But if there's video, let's say there's surveillance video, I can't give you that at the jail. It's on a disc. What are you going to do with a disc at the jail? You can't watch that. You don't have a way to watch that.
I mean, I would be signing a private investigator too, right? By me representing myself.
Nope. You don't get an
How do I
investigator.
do my investigations and this part of the process?
Well, we're going to talk about that, but you don't, I mean, that's a reason to say, you know what, I will take a lawyer because that lawyer will have an investigator and that investigator.
But can I hire my own private
Well,
investigator?
with your money, if you got money for it, you can hire anyone you want. But I won't be providing you money to go hire an investigator because you're saying I'm handling it myself. I got this. Mr. Pierce has it, which means your family would be, they could be helping you or an investigator or something like that. Or there may be some way, and I can't teach you how to do it, where you could petition to get funds for an investigator, but that's not for today. One of the consequences of representing yourself is there isn't someone who comes and sits down with you and say, let's look at this discovery. Man, the way the police handled that looks like that's a problem to me. I've been a lawyer for 20 years. I've never seen a police officer do that. That's something a lawyer could tell you after he or she reviewed all the discovery. And you won't get you're not a dummy. You could look at it and say, hey, this looks suspect, but you'd be making that decision without a lawyer helping you think about it if you represent yourself. Do you understand that?
Yes, sir.
Okay. But you seem concerned that someone hasn't already come to the jail to talk to you about what's in the indictment.
I'm not concerned. I was just,
Okay.
wasn't informed on it. I
Right.
know I was supposed to get a discovery package at least, or
Well, not yet.
report an indictment or something.
You will get it if in the end you convince me that I should let you represent yourself, then you will get all that stuff. But no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that. Or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself. And if we get through this conversation, then you'll start getting discovery. Let me tell you what you're charged with in the indictment. Count 1 charges you with murder, and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. That's count 1. Counts 2, 3, 4, 5, and 6 are all, and 7 and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. Although that's just Brandon Baker. Brandon Baker apparently was a convicted felon at the time of this murder, and the murder was in February of last year. Oh, you are too. There you are. So you had a felony conviction as well. You and Mr. Baker are charged with attempted robbery, and the allegation is, and again, these are just allegations. It's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13. 14 is just Mr. Baker. 15 is you. And it says that on that date, you had a firearm, but you were a convicted felon because back in 2010, you got convicted of something in Clayton County. And also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking about.
Yeah.
So the thrust of it is, the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result of that. That's what you're charged with. Today is not the day to say, I didn't do it, it was self-defense, I wasn't there. That's your defense for another time. That's what you're charged with. So,
Because I have it now?
pardon me?
How many counts I have it now?
It is,
Because I came here having 6 charges.
it's about 12 charges, but a lot of them overlap. 1 count of murder, several felony murder counts, because each of those other things I mentioned, the attempted robbery, the armed robbery, the aggravated assault, that creates a felony murder count. And then you've got a couple charges, all for possessing the same gun, but because of your criminal history, it can be charged in different ways.
So they got me charged with 3 different possession charges?
1 for possession of a firearm during the commission of a felony, and then 2 possession of a firearm by convicted felon, because you have a serious violent felony, your armed robbery, that leads to 1 type of possession charge, and the other, you've got this escape conviction out of Clayton, and that supports a different type of charge for possession.
And what that charge is?
It's possession of a firearm by a convicted felon, but it's a different type of convicted felon.
I got 2 possession of firearms.
You do? Yep. And those may not be good charges. I don't know. That's what you would talk to your lawyer about, or that you'd research on your own if you're representing yourself.
All right.
All right. Do you understand what the penalties are for these charges?
Yes.
You understand that for this murder charge, you could be sentenced all the way up to life without parole, meaning you would die in prison.
Yes.
Same with all the felony murders.
Yes.
You understand that they'd all merge. You can't get more than 1 life sentence for the murders.
Say it again.
You cannot get more than 1 life sentence for the murders. You understand that?
Mm-hmm.
They'd all merge together. But depending on how the case played out, armed robbery also, you could be sentenced up to life in prison. You understand that?
Right.
Okay. And then the other offenses, they're lower sentences, but still serious. But the big one is murder with the possibility, not the guarantee, but the possibility of life or life without parole. You understand that?
Yes.
Okay. Are you a U.S. citizen?
Yes.
Do you understand that if
I'm not a United States citizen.
well, I'm not trying to trick you. Were you born in the United States?
I'm not a United States citizen. I'm a American state national.
Okay. Tell me where you were born.
I was born at Greater Hospital.
All right, a Grady baby. That's all I need to know. There are a bunch of questions I can skip if you were born at Grady Hospital. If I decide that it is appropriate for you to represent yourself, do you understand that you don't get to change your mind partway through the trial?
What you mean?
Well, here's an example. In your armed robbery trial, you were able towards the very end to say, you know what, I want to plead guilty. I want to switch it up. I'm going to plead. Let's take this away from the jury. If you go to trial as your own lawyer and we get partway through and you realize, dang, this is harder than I thought. I don't really know what I'm doing. You don't get a call a timeout and say, Judge, find me a lawyer.
Oh, yeah.
If we start representing yourself, we finish representing yourself. Start to finish, you understand?
Okay, so if I represent myself, later on down, I can't have my family hire me a lawyer.
That's different. That's different. I wouldn't appoint a lawyer.
Okay.
You could bring in a hired lawyer whenever you want, knowing that if we're in the middle of trial, you could bring someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, this is a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because he doesn't know what hearsay is. Do you understand that? Whatever rules apply to the state, and if you had a lawyer, your lawyer, they're going to be the same rules for you.
Understood.
So if you are asking questions of a witness and you really, really, really want to get this exhibit in, Judge, I need to let the jury see this. If you don't know what questions you're supposed to ask to get it in, I don't say, psst, ask these 3 questions. You got to figure it out on your own. And if you can't, then this doesn't come in as evidence. You understand that?
I thought you were supposed to admit the evidence before you start trial.
Well, sometimes it works that way, sometimes it doesn't. It can work that way, but sometimes in the middle of trial, like, hey, you know what? I want to admit this now. But you don't get to ask me questions about how do I do this thing.
Oh, yeah.
If there's an objection and I sustain it, and you look kind of confused, you're just going to stay confused. I don't take a time out, have the jury leave the room and say, here are the 3 things you need to do to get this piece of evidence in. You understand that?
Yes.
That's one of the reasons why I think it's a bad idea, because I know you're smart and I know you've been doing some legal research, but I also know that you're not a trial lawyer. And so you might not know how to get something into evidence because you don't know which questions to ask, but you're aware of that. You know that's the rules. Do you understand, Mr. Pierce, that by choosing to represent yourself, you may miss possible defenses, legal arguments that a lawyer could make on your behalf to try to convince the jury to find you not guilty? Understand that?
Yes.
Yes? Okay. Do you understand that anytime that you fail to make what would be a valid objection, let's say the prosecutor is asking a leading question, and if you objected, I'd sustain it. If you fail to object, that evidence is coming in, and you don't get on appeal, say, wait, that evidence came in. Because if someone doesn't object, that's not anything that can ever be appealed. Do you understand that?
Yeah.
Okay. Do you understand that I will not be making objections on your behalf? I may be thinking, this prosecutor is breaking every rule in the book with these questions, but they're rules of evidence. And it's not my job to hit the buzzer and say, that's not a fair question. It's your job to hit the buzzer and say, I object. You understand that?
Yes, sir.
And I won't give you a little signal like a wink saying, hey, now's the time to object. It's you're on your own, sink or swim. You understand that?
Understood.
Okay. Do you understand that unless you take the stand and testify, none of the words that you say to the jury will be evidence in the case?
What you mean?
So lawyers are, you saw your trial. You said, hey, it ended before closings. That means you saw openings, opening statements. Then when the prosecutor got up and said, Pierce is a bad man, he did an armed robbery, you'll hear the evidence, and he held a gun to someone, whatever they thought the evidence would be. None of that is evidence. All of that is the lawyer talking, saying, here's what you may hear. You'd be free to give an opening too. And your opening might be, I wasn't there. It was all Mr. Baker. You're going to hear evidence that I was in Louisiana when this crime happened. That's not evidence that you were in Louisiana. That's just you talking to the jury. And I'll be telling the jury that nothing that you say when you're giving your opening or that the prosecutor says while she's giving her opening is evidence. It's just some guidelines that the jurors could choose to follow as they're thinking about what the case is about. The only way you would get evidence in is if you choose to testify or if you figure out how to admit exhibits.
Question.
Yeah.
What's the difference from me starting an open argument and a lawyer starting an open argument? It'll be admitted evidence if a lawyer start an open argument.
It's not. Nope. I tell the jury before we start the trial that you're going to hear from, if you represent yourself, I won't say the lawyer, I'll say you'll hear from both sides. You're going to hear from both sides an opening statement. That's not evidence. It is a preview of what each side thinks the case is about, but it's not evidence. And you didn't get to hear this because you pled out before then, but I would say, as would any judge before closing arguments, you're about to hear closing arguments. These are not evidence. These are arguments from both sides saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you'd need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Right. Otherwise, you could just get up and give an opening saying, I didn't do it, or it was self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that?
Yeah.
Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case, someone who is not connected to what happened or didn't happen in this case.
What you mean by that?
One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage and you're wearing a t-shirt that says Ricky Pierce and your fingerprints are on the gun and your DNA is at the scene. I'm making this up, but a lawyer could say all this and say, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting the guy, and you're standing there looking as scared as the poor guy who got shot. I don't know what the evidence is. I do know that having your own lawyer means someone who is independent, who isn't running the risk of going to prison, can look at this and say, this is a good case for you, or this is not a good case. You will never get that independent assessment of the strength and weakness of the state's case if you represent yourself.
Right.
You understand that?
Yes, sir.
Okay. Do you understand that the prosecution will be free to bring in the most experienced attorney it wants? I won't say, hey, Pierce isn't a lawyer, so you need to bring in a brand new prosecutor who's never tried a case before, so it's more even. Understand that?
Yes.
They could bring in the big guns, and that's your problem and not anyone else's. Understand?
Yeah.
Okay. Do you understand that I will not ever tell the prosecution to go easier on you as the opposing side because you're not a lawyer?
Yep.
I'll expect them to treat you as respectfully as they do defense attorneys because you ought to be, you're the other side, but they aren't going to need to pull punches with objections or anything like that. If they think something wrong has happened, they're free to object. You understand?
Yes.
Okay. Do you understand that if you are found guilty at trial, you will not be able to argue on appeal that you were a bad lawyer for yourself?
Understood.
Because that's a claim that a defendant can always make if he's got a lawyer. It's called ineffective assistance. See, you know stuff, but you cannot say I was ineffective, meaning Ricky Pierce was ineffective.
Right.
You may have been very ineffective, but you don't get to argue that if you're your own lawyer.
Understood.
All right, you're understanding all the stuff you need to. Do you understand that you will not get extra time to prepare for trial just because you're representing you're gonna have plenty of time. Trial's not tomorrow. But if you say, you know what, I need a year to get this done, I'm gonna say, no, you don't. You're not gonna get any more time than I would give the lawyer that I would appoint to represent you. Or if you hired a lawyer, I wouldn't give that lawyer a year to get ready. There's a family that's grieving because of a loss. You're sitting stuck in jail. And so we need to move this case along. I'm not going to rush it, but I'm not going to go slowly just because you represent yourself.
Understood.
All right. Do you understand? And this is something we've already talked about, but it's important we cover it again. Your ability to investigate this case and do legal research will be very limited by the fact that you're choosing to represent yourself and you're stuck in jail.
Yeah.
You got that? You appreciate that's a disadvantage.
Yeah.
But it's a disadvantage you're willing to eat.
Yes.
Okay. All right. You understand if you had a lawyer, you hired one or I appointed one, that lawyer would not be stuck in jail with you. That lawyer would be able to go out and you could say, hey, you need to go interview Fred Smith. And they'd try to find Fred Smith. And they'd have an investigator who could try to find Fred Smith. You understand that?
Yes.
You're going to need to figure out how to do that on your own. Right? Okay. Now, if you had a lawyer, you understand that that lawyer could give the opening statement for you, could do the jury, we call it voir dire, but questioning jurors in advance when you're doing jury selection, could interview witnesses, subpoena witnesses, prepare jury charges, do closing arguments, cross-examine the state's witnesses. A lawyer would, should, and could do that for you if you had a lawyer. You understand that?
Yes.
And you won't have any of that if you represent yourself.
Yes.
All right. Has anyone threatened you to get you to waive your right to a lawyer?
No.
Has anyone promised you something to get you to waive your right to a lawyer?
No.
Mr. Pierce, do you want to represent yourself, at least for now, in this case, understanding that the only way you can undo that is by saying, I hired someone. Here's this lawyer for me, because otherwise you're telling me, no, I got this. You understand that?
Yes.
And do you want to represent yourself?
Yes.
Okay. Well, I find, and I'll get this in writing and enter an order to that effect in the docket, that you're aware of the charges against you, murder, felony murder, aggravated assault, armed robbery, etc. The consequences you face if you're found guilty, up to life without parole. The advantages of having a lawyer, outside investigation, independent opinion, legal expertise, etc. The disadvantages of having no lawyer, hard to investigate, hard to do legal research. But I find that despite all those things, you have made a knowing, intelligent, as in you get it, and voluntary, no one's forcing you, waiver of your right to counsel, and you are exercising your right to represent yourself, and I'll grant you that right. Any questions about any of that?
No, sir.
Okay. We got, so two things. One, I'll make sure that, Mr. Abate, is this your case? Okay, that's your prosecutor. I'll make sure Mr. Abate gets to me as much paper discovery as they've got. Again, there's often lots of digital discovery. I'm making this up. I don't know what's in the case, but let's say your cell phone was seized. They might have done a cell phone dump, and there's a big old file that lists all the pictures and texts, and sometimes, maybe not in this case, after something happens, Baker texts to Pierce, I can't believe we shot that guy. And Pierce says to Baker, hey, we need to not talk about this anymore. I heard the dude died. That's great evidence for the state, but that's digital evidence. And so that might not be something that can be handed to you to look at in
How would
jail.
I access?
So what you'll get is all the paper discovery as well as a list of what is the digital discovery, body cam footage, surveillance footage. And then you would let me know. We'll have a status conference so I can see how things are going. Hey, Judge, there's some things I need to watch. And we would set up a time when you could be here and there'd be a laptop and that stuff would be there and you could watch it and take notes, whatever you need to do. It's not convenient for you, but that's how it works when you are representing yourself and you're stuck in jail. So my answer is not you can never see it until trial. It's just we have to develop a little bit of a workaround. And so you'd be watching it here. You can't just watch it anytime you want. We'll set up a specific time and that's how you digest it. Okay? I'm not saying there's any digital discovery, but if there is, that's how we do it. So I'll get from the state the discovery. We'll figure out how to get it to you. Either we'll bring you over here and hand it to you. That's often my preference because it's on the record. I see you getting the discovery, or through the sheriff's office, we'll get it to you. Are you at Rice Street?
Yes.
Okay, we'll get it to you at Rice Street. Mr. Abate, what would you say the ratio is in this case of paper discovery to digital discovery?
A lot of digital discovery.
Okay.
Mr. Baker's cell phone extraction. And there's a lot of video surveillance, some of which this defendant, Mr. Pierce, is seen in high definition video shooting the victim in the head.
Okay, so there are things he'll need to see.
Yeah.
Okay. When you generate the paper discovery, would you please include, you don't need to list the description of each video, but 9 surveillance footage, 9 surveillance videos, 2 body cams, whatever the generic count is. So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen 1 body cam and it says there are 2. We can sort that out. Thank you. So you'll get the paper discovery, and then clearly we're going to need to figure out a time when you can come here and watch it. You get to watch it privately. The prosecutor's not going to be there while you're doing it because you may have a reaction to it, and take notes, whatever you need to do. That's number 1. Number 2, are there things that you think we need to talk about now, or now that you represent yourself, are there instead things that you want to get in writing and file as motions?
Yes, I have 2 motions that I want to file. I have them wrote up now in my thing, and there's a lot of issues that I have to address as far as with me being a national, just putting it on a record for my benefits.
Okay, so let's do that. Let's do 2 things. 1, I want you to put on the record, we're going to just do it. You're free every time we're in court together to remind me that you're American State National and you don't think that there's jurisdiction. But what I would ask you to do, you're going to share, it sounds like a fair amount right now, to get it on the record. We only need it on the record once because you will have made that record. And then in the future, all you need to do is say, hey, I rely on the record I made. You don't even need to state the date, but that I made before about my objection to jurisdiction or whatever you want to call what you're about to share. So I'll always let you make a record. But I will push back a little bit if next time I see you, like, hey, I need to make that same record again. No, you don't. You made it, and you only need to make it once. And then there's a transcript so that if you need to take something up on appeal, they only need to read it once. All right?
Would I get transcript from every court proceeding? Or how do that work? Do I have to file for it?
So
or automatically get it to me? By representing myself.
So every time Ms. Rivers is taking something down, we can create a transcript. We don't immediately generate transcripts because, for example, if you go to trial and you're found not guilty, we don't need to create a transcript of any of that because you're done. You go home. If you're found guilty, then we need to make transcripts of everything because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as an example, let's say we had a suppression hearing and the lead detective testified and talked a lot about the work that she did on the case. Everyone wants a transcript of that because she's going to come back at trial. And if her story changes, then someone wants to say, wait a minute, you were in court 2 months ago and you said Mr. Pierce was wearing a blue shirt and now you're saying he's wearing a red shirt. Which one is it? And the jurors are wondering, why is this detective changing her story? But things we're saying today, that kind of transcript we'd make only if you're found guilty and we need to push stuff up to the Supreme Court. But it is being preserved if Ms. Rivers is here and doing what she needs to do, which she is. So why don't you briefly share with me the things you want to get on the record?
Your Honor, let the record reflect that I'm American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps Legal Fishing Corporation or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request of me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction and have proof of it when I came to court on January the 30th, 2025. Your courts, plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the Admiralty and Maritime Laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under Admiralty and Maritime Laws, which is a foreign law to sea jurisdiction. See Article 3, Section 2 of the United States Constitution. And no living people live there on the dead persons, legal fictions, corporations, and dead entities, because all cities are considered dead entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American State Nationals, and also can't happen because our nationals is not under the court's jurisdiction and will not show one order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under Admiralty and Maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof of this when I came to court January the 30th, 2025. I also mailed off my executive letter, the notice that President Trump sent off January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed off a copy of my certified mail. I mailed off certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, Our statutory and foreign laws are also dissolved. The only legal framework that remains in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which makes this contract void, which means the court lacks subject matter jurisdiction over me. I am no longer an employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the de jure government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, but including but not limited to any incorporated church, synagogue, mascot, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud. I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail, these 150 plus days, and it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows. 1, these are all combined municipal and territorial notices of violations against Americans with failure to perform any and all occurrences listed below in this section, starting at $10 million. A, notice of claim of sole relief and remedy. B, notice of violation of the Landman Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8, and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D, notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E, notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F, notice of violation of presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790, as originally enacted. G, notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H, notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I, notice of violation of the United States Statute at Large Act, Title 12, Section 411. K, notice of violation of the Geneva Conventions by the United States Department of Defense.
Mr.
of the United
Pierce,
States.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure you're almost done because we're getting into international stuff and that's getting a little far afield.
All right. 2, private easements fee schedule. Penalty for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Compulsion to produce trade name or other identification materials. A, name, $50,000. E, fingerprints, $200,000. F, photographing, $200,000. G, DNA, $5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commerce or trade. M, color law, $150,000. N, implied color law, $150,000. T, fraud, $1 million. U, fraud upon the courts, $2 million. BB, stimulating legal process, $1 million. Use of trade name and copyrighted protected material on threats, duress, and or coercion. Name written by a informant, $250,000. Miscellaneous material written by a informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees will result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on a protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and this is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
I really need to get it on the record, and I need to file the motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on a protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on a protest and duress, $33,500. 60 minutes on a protest and duress, $75,000. 90 minutes or more on a protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor no bond, honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, codes, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000. Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3 for a total of all damages added to a 3 times the damage for appearance and other additional damages for a total of $1,019,631,000 US.
1 billion, you're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws, but codes, statutes, mandates, regulations, and all the rest. And I'm a private American or not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal. And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you war against this is warring against the Constitution, and warring against the Constitution is called piercing the veil, and piercing the veil is called treason. Treason is punishable by death, and there is no remedy for treason. Also, in Orange versus Independence, officers of the court have no immunity from persecution when violating the constitutional right. I am honored the United States of America, the Danjur government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times and I don't understand it. The what government?
The Danjur government.
What is, spell that?
D-E-J-U-N-E, space J-U-N-E, Danjur.
D-E?
J-U-R-E.
Oh, got it. Okay.
Danjur.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me after I put them on notice of my political status. Your Honor, United States, the de facto government, is a for-profit corporation, which means they have a Dun and Bradstreet number, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Cruden versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British monarchs, both of whom were honor bound to act as trustees for United States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed the secret treaty of Arraignments and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as privateers. That's why the Bar Association requires licensing. Acronyms for bar mean British Accredited Registry. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold rings around the flag, around that war flag, because the war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans to bind by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we on?
What am I almost doing? I'm closing now.
All right.
Again, I am 1, changed from jurisdiction of the courts. I have a high jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the courts permission to use the all caps trust, which is a copyright and trademark. I am putting the courts on notice that I have occupied my executive office again, and I am standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief of my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, I, the petitioner, case will not being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case was not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the court, the state, to show up in proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for two independent reasons. First, it may fail to get a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States. See the United States Constitution. Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hamlet case. Your Honor, the Constitution is a chapter of negative liabilities. Liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason. See case law Cooper versus AURON, 358 US.1,78S.CF.1401 1958. Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this contract and was too young even know that this contract exists, that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You are welcome to file things now. Because you are your own attorney, you can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So is I can leave these motions here today?
So this one time, I'll take responsibility for filing things for you.
You know what, I'll wait, because I still have some other.
You want to do more work on it?
Yeah.
Okay. There is a way for you to file things from the jail, and they ought to tell you about that, but you can get things to the clerk's office. Don't mail them to me, because if you mail them to me, I'm not the clerk. They won't get in the docket. They go into my inbox, and I've got my Pierce collection. You should also know if you send things to me, I probably need to send them to the prosecutor as well, because we can't have what we call ex parte conversations. In the same way that the prosecutor can't call me and say, let me tell you what Pierce did. That won't happen. If Mr. Abate wants to talk about this case, you need to be in the loop as well. And so we'll bring you over here, or if it's real simple and technical, we'll get you in a Zoom booth so you can see and hear. But if it's anything substantive, you'll be here in person in open court for that. Okay? So what I see as our next steps, then I'll see if the prosecutor has anything else, and I'll see if you have anything else, is that I'm going to get a scheduling order in that gives a deadline for Mr. Abate to get together the paper discovery and then a list of what the digital discovery is, and we'll figure out how best to get that to you. I need to enter an order that says you get to represent yourself, so that's in there, and then we move forward.
Okay, cool.
What about you? Yeah.
Last time I was here when I went to trial, they had where I went to the law library and look at video footage. That's not possible anymore. Well, yeah,
I don't know. Meaning you went to the law library at the jail,
yeah,
and you were able to
They had an officer supervise me to watch the videos.
Okay, why don't you ask? That's a question you need to ask the folks out there. I don't control the sheriff's security protocol. They may still do that. They may have cut it off because someone said it's video footage and instead it was an adult movie or something. And that's not you, but someone may have done something that abused that privilege. So ask, and if the answer is there's a way to do it, we'll make it happen. What I do know works, because I did it the last time I had a pro se defendant, is that he came here and we had a laptop. The prosecutor brought in a laptop and said, here's the directory, here are the 5 videos. Prosecutor went away and you hit play and you got to watch them. Took whatever notes you wanted and then you went back. So worst case scenario, we'll do that. But if you figure out there's a way to do it at the jail, then we can talk about making that work.
Who I need to contact? I think I need to contact the sheriff office, the sheriff or something.
It would be someone at the jail. I don't know who you talk to if you want to go to the law library or if you've got a headache and you want a pain pill. I would talk to staff out at the jail. Hey, if I want to do X, is there a way to do it? If they say there's not, then we got to do it over here.
All right.
Okay.
Understood.
Any other questions?
No, sir.
Mr. Abate, what do we have from the state?
So on the last issue you just, or Mr. Pierce just raised, I don't believe the jail does that anymore.
I don't either, but
the USB and the or CD, they just don't allow that kind of what they would call contraband at this point. So we can ask, or he can ask obviously, but just for efficiency purposes, I think.
Start with the law library. Just see the law library still do it.
you should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket and then it's on the 7 North and I'm not saying you did.
Is it part of me possible they I ain't gotta take it, they can stick it in, sit there, watch the whole video.
Hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. That's 100% the chief jailer's call. And they may have said, we're not doing it anymore. And if they're not, then you come over here and we'll make it happen. Anything else?
No, Your Honor, I'll get paper discovery this week.
Great.
To Your Honor, and then I will, in abundance of caution, put all the digital media on the drive just in case.
Good.
And regardless.
Well, and that would be helpful because if you include that with the paper discovery, then you don't even need to be in. If we can get our hands on a laptop, then we'll let you know when Mr. Pierce is coming over, but we may not need to impose on you to show up with the stuff loaded on a computer. I don't know. I don't want to get in the middle of the technical stuff, but I do want to enable Mr. Pierce to see what the state has.
I have no problem logging in a laptop when he's here. We did that with Judge Ingram on multiple occasions, and it seemed to work pretty efficiently.
Good, I think so.
And Mr. Pierce is an ANC recidivist, so he is facing a convicted and mandatory life without parole sentence.
Okay, and is there a recidivist notice in the docket?
Not at the moment. I intend to file
Okay. Mr. Pierce, I'm gonna translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're gonna do, that if you're found guilty, and all this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if, and if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole, but if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case. Don't know, but we'll keep you posted. Okay? I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. All right?
So, question before we go. How much, do I have like a certain amount of time to file all the motions that I need to file, or how do that work?
So there'll be a scheduling order that comes out, and we'll need to make sure it gets to you. And that's got a deadline for the state to get discovery. And then you've got a deadline after that, so you can see all the discovery to file motions. Okay. You can always file a motion later on. I just don't promise you that I'll get to it before we get to trial, because you want to avoid a defendant just before trial. It's like, oh, I got another motion and another motion. So you're going to want to start filing things. If you already have them here, put them down on paper and start filing them. But you'll get this scheduling order that's got the cutoff where anything filed after that date is out of time, and I can choose to ignore it, and I don't get in trouble with the Supreme Court.
Okay.
Okay.
And question, I know I've been having a conflict with attorneys, so does my time from this day, today on forward, start me to file my speedy trial? I know it's a certain time frame for you to file a speedy trial. So does that time frame start now, since we have an understanding?
Right. It started from when you were indicted and not now. So you can still file, well, I'm not going to give you advice. You should file what you want to file, and we'll work through whether it's a mandatory speedy trial or if it's a discretionary one. But I'll tell you, no one's interested in slowing this down. Mr. Baker is on a trial calendar that starts in a week. And I'm having to slow that down because really you two ought to be tried together, unless someone can convince me that you shouldn't be tried together.
Are you going to try it together even if I'm not a citizen?
Yep. We can try a citizen next to a non-citizen. That's not, the only reason you don't try people together is if there are reasons why there's some evidence that can only come in if they have separate trials. But I leave that up to the lawyers and you to work through that. My default is always to try co-defendants together. And Mr. Baker's case is ready for trial. So if you say, I want a speedy trial, no one's going to say, no, let's slow it down. They'll want to move it along. But you file what you want to file, and I promise you we'll work through it. Okay? Okay. All right. Thank you, deputies. You can take Mr. Pierce back.
There y'all.
Judge, as an update, success.
Good, given how much time we just worked, you should have everything done, but thank you.
Yeah, working on that.
Yes, do we need to keep folks apart here?
I'll make sure that.
Make sure they stay apart. Thank you for sitting through that.
Mr. Rivers, you are.
But you know what? We got that out of our system. Who's coming out now?
Christopher Shanks, can we do the plea for Christopher Shanks?
Sure, yeah, that's fine. I think all we have left is Shanks and Cook. Is Cook a 2-minute conversation?
I think we can probably bring him to the door.
That's fine. Have Mr. Shanks right there. If we just have Mr. Cook right there in the doorway. Nope, if you're Shanks, you can stay right there. That way, Ms. Dilligard can get out of here and you can get out of here. I've noticed you both looking at your watches. I warned everyone Pierce was going to take a minute.
These are the indictments. They got indicted. This very soft.
So.
30.
Hey, Mr. Cook, how are you? So, I wanted to let you know what's going and what's not going, because Ms. Wood has done a real good job of keeping me posted with your frustration, et cetera. In order for your pleas to get traction and for you to get out, that program needs to be in place. And my understanding, I'll hear from you in a minute, let me finish. My understanding is that Hope House, which is where you were hoping to go, somehow the I's aren't dotted and the T's crossed yet. That doesn't mean we have to do Hope House. If Hope House in the end says, it's not gonna work, Ms. Ross, you met Ms. Ross before? She can let, whether it's Georgia Works or Stand, there are other programs we could get you into. But until there is a program, I'm not gonna sign the final piece of paper because I want you plugging straight into that program.
Cases.
Okay,
I'll
good.
probably get my own.
Do I have to wait another 9 months?
No,
But that program and stuff go on through there. I don't mind what program I go to. I just don't want to go to drug court. That's out right there.
You got money?
drug court is out. That's a true statement.
Anything else, I don't mind going to.
Okay.
But what I'm saying is I
But
can
well,
wait
maybe you'll
9
live with her
months.
for a while, then you
Just
find
to get
a
into
place.
I
Okay.
don't mind doing it. I got myself in this, I can try to
Okay.
work myself
And
to
you're
get
gonna
out.
have no
Yep.
contact
But
with
what
the
I'm saying
victims,
is
so
I'm
that
gonna,
okay
I'm
with
gonna
that?
keep
Can
waiting
you?
9 months for a program to get into a program to get out of it.
So it's been a couple things. It's been that, but you also have been somewhat prolific. You got a lot of cases, and Ms. Wood has been trying to make sure we've got all your cases in one place, so you don't plead and you think, I'm ready to go, and the sheriff grabs you and says, oh, you got another case still.
FVIP, stay away.
Now we do, and Ms. Ross is like, it will not be 9 months. I may see you again in March. I mean, that's how quick it'll be.
Stay away, no alcohol.
Another 10 months? If I see,
No weapons, maintain.
okay, I can't, I'm not gonna sign anything till there's a program in place. And
How
so,
long do I have to wait for a program to get it? Judge, we should have an update like this
They don't
week
have a- they don't have
because
to- they don't
they
have
came
to
to
go
see
over
this morning, I explained
That's
that to
the
them.
law.
Yeah.
Ms. Ross let them know like he's at the courthouse.
right, and he's ready to go. He's clearly anxious, which is why I'm saying, I expect to see you again in March. We're in March now. So I'm not talking 9 months, 10 months, or anything like that. So my advice to you is deep breath. I know you're frustrated, and it's your time. It's not mine. I know, I'm not sitting there at Rice Street. But I'm anxious to close your cases out as well. You got a bunch of work on my docket. It'd be great to be done with that, as long as there's a program.
That's what you're doing.
When do I see the?
You know what I'm saying? Because the failure to appear,
I
that's
texted
something that
Ms.
they won't let
Ross,
you out.
let them know that he's here and not there, which they found out already.
Oh, someone was trying to see him?
It is
Yes.
all that is.
Okay.
And another, he's housed at
And then
Anna
he gets
Spirit,
sentenced.
and there's
Because all that
things
is.
Good, because he's doing so well in custody.
Yes.
Another reason to get him into a program.
Exactly, Judge.
Okay.
She's trying to get that rescheduled for this.
Yeah, so it's this week. They're gonna see you this week. Once I get that green light, whether we get you on our Zoom, I have calendars almost every day. And so we'll get you on Zoom, we'll get you over here, and we'll close this out. So it is fair for you to be frustrated. I get that. I'm asking you, a couple more days, let's iron this down.
Because I got myself in the position I'm in now. I'm trying to work myself out of it.
Good,
I don't need,
Right.
all I need is somebody to help me help myself. That's all I'm trying.
good. Well, let's buy into that, because I don't wanna see you 6 months from now, because you got out and you left the program, and here's Mr. Cook again, so.
I'm not the one trying to do that. I
Good.
came here, I turned myself in and tried to get some more.
Good.
I'm gonna do something now.
All right, well, you'll meet with these folks. I will see you again, if not this week, then probably next week, okay? Bye. I don't think I see you guys tomorrow unless you're involved with the Cherry case, which is Cabrera and Abate. He has some non-major cases. Is Mr. Abate gonna handle those?
Yeah, I believe he's resolving all of his cases.
Yeah,
Excellent. That's some dead bodies.
See you on Thursday, Judge.
All right, you guys take care. Sorry to keep you standing up there. You have a bunch of cases too.
Cyrus says defendant.
Ms. Rivers, are you wanting a break or are you ready to knock these pleas out? Amen.
That was
update much.
Yeah. I appreciate you getting down what you could get down. No, nope. It was important to get that out of his system. I don't think we have another Pritchett on our hands. I think he got that in out.
Cyber says defendant.
Well, but if he comes back and we don't have to hear that again, then that's a better situation. Mr. Patrick, how many cases are we handling today?
4, Judge.
Great.
You have 7 months left.
So I have to serve the whole 7 months.
That's up to the count. They do count, but he has no control over that. But yeah, right now, yes, that's it.
Can
Consider it, yes.
I see the accusations back? I don't remember the case number.
Oh, okay.
Yeah, I'll get you to sign them as soon as we enter the plea, if that's okay.
Yeah.
Thank you.
You missed out. Why were you not here for all of that? Jeez. Whatever. He's like, hey, I need coverage, snack time. She had to stand through all this. It was so bad her body camera started making noise.
Sign here.
Yeah. Yeah, at least we didn't have to type it all up. And the real victim here, yeah. There was flame coming off her stenographer machine. All right, are we ready? You can be wherever you want to be. I just need to get the right camera on. You're going to be right there?
I can sit right here, Judge.
Okay, great. Oh, I don't know that camera is working right now, but I can take the witness camera off at least. All right. Let's get on the record. This is Mr. Shanks. He is in court with his lawyer, Ms. Rios, and we are taking a plea in 23 SC 191719, along with a bunch of other cases. And I'll let Mr. Patrick get those into the record in a moment. Mr. Shanks, we're going to take a plea. It sounds like in a total of 4 cases. You're going to be under oath and answering questions from Mr. Patrick about your rights as a criminal defendant. It's important you answer all those questions truthfully, which I know you'll try to do. If you've got questions while we're doing this, you need to let me or Ms. Rios know. Will you do that?
Yes, sir.
Okay, then let's get started.
Yes, Your Honor. The state of Georgia is, first, we'll do it just temporally, if that pleases the court. In 23 SC 191719, the defendant stands accused of 1 count of battery family violence. There, Judge, the state would show that on the 18th of August of 2021, Officer McAlpine, McCalpine, of the City of Atlanta Police Department encountered the victim Kaylin, Kaylynn Sanders, who informed him that this defendant had struck her, which was using his hand, resulting in visible bodily injuries to Miss Sanders. Additionally, Judge, we're moving forward a little bit in 25 SC 001315. The state stands accused of 1 count of battery family violence, in which the defendant on the 23rd of November of 2023 again struck Miss Sanders with his hand, resulting in visible bodily injuries. Moving next to 25 SC 001316. Judge, this is actually the controlling case for sentencing purposes, in which he stands accused of 1 count of aggravated assault. In that he did, on the 14th of December of 2022, place his hands about the neck and throat of Kaylin Sanders, applying pressure, resulting in strangulation. And then finally, Judge, 25 SC 001317, 1 count of aggravated assault, 1 count of burglary in the 1st degree, 1 count of criminal damage to property in the 2nd degree, 1 count of battery family violence. Judge, the state would prove that on the 24th of September 2024, the defendant, again, Kaylin Sanders, placed his hands about the neck and throat of Miss Sanders, which could have resulted in strangulation.
and that he did so after entering Ms. Sanders' home without permission, which resulted in damage to the door frame that exceeded $500. And additionally, Judge, he did leave abrasions about Ms. Sanders' neck. As far as the plea goes, Judge, as to 25 SC 001316, state is recommending a 5-year sentence with the first 1 year to be served in confinement. He's done about 6 months of that, Judge. Upon release, he is to have no contact with Ms. Sanders. He is to complete the family violence intervention program. He is to abide by all general conditions, including possessing no firearms, no alcohol or drugs without a prescription, and maintain gainful employment. As to the next most serious case, 25 SC 001317, again, count 1 is a 5-year sentence with the first 1 year to be served. Counts 2 and 3 are to run. Judge, the state will remove the gainful employment requirement, although, I mean, to be completely frank, I don't think we discussed it. I think it's part of the general conditions, but I will remove that since we didn't discuss it specifically, although the state will note for the record that that is probably the least obtrusive of the requirements.
Okay. What's the concern about? Is there a disability or just no one agreed to be working?
He's getting a settlement and he might not need to work.
Okay. Got it.
Oh, well, cool.
Yeah. Use it wisely. Okay.
So Judge, counts 2 and 3 are going to be concurrent with count 1. Count 4, the state would note as a operation of law would merge in to count 1. The visible injuries as part of the strangulation. And then both the case that was on the calendar, 23-19-17-19 and 25 SC 13150, those are both 12-month sentences to run concurrent with count 1.
Is the case, the 23 SC case, it's a misdemeanor? Or is it a felony because there was a prior?
It's a felony, but pursuant to negotiation, we're running it together.
You're welcome to run it together, but wouldn't the sentence be 1 year? I know this sounds like a meaningless technicality, but if the case ending in 719 is a felony family violence battery because Mr. Shanks has a prior one, then 12 months isn't a sentence I would impose or could impose unless you're reducing it to a misdemeanor. I don't know what the basis would be for that. It would be 1 year. It doesn't change anything because I would run that 1 year concurrently if I follow the recommendation with the 5 to serve 1. But I was going to ask when you were done, hey, are these 2 misdemeanor cases or are they 2 felony cases, the 2 family violence batteries?
They would be felonies judged by operation of law, and just as a knee jerk, when I see battery family violence, I said 12 months.
Yep. But here it's a year.
Here it's a year.
Okay, got it. But it's just straight year to serve. So there are only 2 cases that have probationary tails, the 2 aggravated assaults, and those are 4 years of probation.
Correct.
Got
Yes,
it.
Judge.
Got
So the aggregate for, I guess, tax, tag, and title is 5 years with the first year to serve. Family violence intervention program, no contact with Kaylin Sanders, no alcohol or drugs, and to use his settlement wisely.
Okay.
Are you ready for me to go through the colloquy?
Yeah, if you'll swear Mr. Shanks in, you can ask him questions.
Mr. Shanks, will you raise your right hand for me to the best of your ability? Do you swear the testimony you're about to give before this honorable court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your first name and spell it for the record, please, sir.
Christopher Shanks, C-H.
You can put your hand down.
CHRISTOPHER, Shanks, SHANKS.
And do you have any aliases, Mr. Shanks?
No.
Okay. Are you currently under the influence of any alcohol, drugs, narcotics, or other inebriating substances?
No.
Do you take any medications on a daily basis?
Tylenol.
Have you had that today?
Yes.
Why do you take Tylenol?
Headaches, migraines.
And how old are you, sir?
37.
And how far did you go in school?
All the way.
Did you graduate from high school?
Yes, sir.
So then I assume you read, write, speak, and understand the English language.
Yes, sir.
Do you understand that you have the right to enter a plea of guilty or not guilty to every single one of these cases? And if you were to enter a plea of not guilty, you would have the right to compel the state to prove your guilt in doing that, the essential elements of every offense before a judge or jury.
Yes.
Do you understand that at a trial you would have the right to testify or not testify, would be your choice and couldn't be compelled otherwise, to call witnesses to testify on your behalf and use the subpoena power of the court to compel them to be here, and for Ms. Rios or any lawyer of your choosing to cross-examine witnesses that are brought by the state? Do you understand that?
Yes.
Do you understand that by entering a plea of guilty, you are giving up those rights that you would have otherwise maintained at trial?
Yes.
Do you understand that by entering a plea of guilty to this charge, you're entering it pursuant to negotiation, which would mean if the judge accepts the plea negotiation, you would have very limited circumstances under which you could withdraw that. First being to withdraw your plea before the last day of this term of court, to file a direct appeal to the Court of Appeals within 30 days, or in the case of felonies, to pursue a writ of habeas corpus within 4 years. Do you understand that?
Yes.
And Ms. Rios can explain all of that to you.
Yes.
Do you, let's see here. Have you had enough time to speak with Ms. Rios?
Yes.
Would you like any more time to talk with her about anything?
No.
Was there any question you asked her that she was either unable or unwilling to answer?
No.
Are you satisfied with her services?
Yes.
Let's see here. And Your Honor, the state is unaware of any outstanding bench warrants. There are two additional cases that the state is going to be null processing. The numbers have changed with the sheriff's office putting all of the right dates. So we ended up with more cases than we had dates.
Great. So when you say dismissing, they're actually accusations, they're SC numbers, or are they PI numbers? Because I don't know that you null process a PI number. You'll know better than I, but you'll make a representation on the record that the state is not proceeding and will not proceed with the two unindicted cases?
Correct, Judge. I call it an E&P, and elect not to prosecute, but I'm not sure what the nomenclature in Fulton County is.
NPGJ, not presenting to grand jury, is what I've seen. But either way, if you're making a record here that they won't go forward, Mr. Shanks is protected because he could always invoke this transcript.
Yes, Judge.
Okay.
Let's see. So, Mr. Shanks, the minimums and the maximums on these cases is going to take me just 1 second. As to aggravated assault, that is 20 years in the service of the Georgia Department of Corrections with a $100,000 fine. Burglary in the first degree is a 20-year sentence with a $100,000 fine. Criminal damage to property in the second degree is maximum of 10-year sentence with a $100,000 fine. The two battery family violences carry, 5-year maximums with a $100,000 fine. So that's 20, 40, 60, 70. That's 80 years and $600,000 is the maximum allowable under the law. 85. I forgot the one that was on my screen. Do you understand that those are the maximums punishable under the law in your total cases? That's not what we're recommending you do, but that is the most the judge could give you.
Yes.
Do you understand that the judge is not obligated to follow the negotiated plea offer? However, if you, as this is a final plea calendar for one of your cases, were you to not, you could withdraw your plea and proceed to trial. Do you understand that you maintain that right?
Yes.
Let's see here. Do you understand that you are going to be going on to probation for a term after your prison sentence is concluded?
Yes.
And that with probation, the general conditions and special conditions, were you to not abide by them, you could be brought back before the court and the court could revoke any or all of the remaining sentence.
Yes.
Okay. Are you currently on probation or parole?
Yes.
Okay. Do you understand that this could have a negative impact on that?
Yes.
I'm going to interrupt. Ms. Rios, Ms. Nelson helpfully provided me with the probation warrant connected with all this. Are you hoping that we can resolve hold on one second. Were you sentenced as a first offender? You were sentenced as a first offender in front of Judge Richardson. So I don't know what she's going to want to do with that. Normally, I would say, why don't we handle the revocation here? But I think we should go forward today, and I'm happy to reach out to Judge Richardson explaining what we did here. And she might say, I don't want to revoke the first offender status, but maybe revoke a year of the probation. I don't know, something that would run concurrently with this, or have you already engaged with anyone about that?
I've talked to probation and we were on the same page. I didn't realize that you couldn't handle it if it was a first offender.
It's not that I can't. If someone has let probation know what we're doing, they filed a petition for adjudication of guilt, which is a way of saying, Judge Richardson, we think you should take away first offender status. That doesn't mean they can't, that's their document, not Judge Richardson, but she signed it. It was 3 months ago when she signed it.
Probation said she was going to let you decide.
Oh, okay, great. Then we're going to weave that in. Okay. Let's keep going.
Yes, Judge. Are you a United States citizen, sir?
Yes.
You understand by entering this plea, you're entering a plea of guilty to felony charges, and these are charges that invoke family violence battery. Because of that, as a felony, you could lose certain rights: the right to vote, the right to possess or transport a firearm, the right to seek or hold public office. Furthermore, because these are acts of family violence, that will also impact your ability to possess a firearm. No matter what ends up happening with any of these cases in the future, should they be sealed, should they be expunged, whatever may happen 15, 20 years from now, you understand that by entering this plea, the federal government or any other state sovereign government may still truncate those rights.
Yes.
You also understand that for anything else, that going forward, here and infinitum, the state of Georgia or any other separate sovereign may use these as factors in aggravation for any future sentence. Do you understand that?
Yes.
Are you entering this plea because you are in fact guilty of the charges levied against you?
Yes.
Your Honor, that is the state's case.
All right. Thank you for that. Ms. Jackson, thank you for sticking with us. We're now after hours. I hope you're collecting overtime. Can you share criminal history information for Mr. Shanks, please?
Yes, Your Honor. He has 11 cycles. The last arrest was October the 26th, 2021, with the City of Atlanta Police Department for battery. There was no disposition for that arrest. He does appear to be on first offender probation. That case number is 17 SC 156213 for cruelty to children in the first degree. That disposition date is November the 4th, 2022, and the term is for 5 years. He does have misdemeanor sentences, one sentence and one conviction. He received a nolo contendere sentence in 2013 out of Jackson County for 2 counts of forgery in the 4th degree. And there was one in 2012 for battery. Nothing in addition, Your Honor.
Thank you so much, and thank you for your time today. We'll see you There's a plea tomorrow at lunchtime. I don't know that you need to plug into that. I think that plea is pretty solid. But hopefully we'll see you Thursday.
All right, we'll see. Thank you so much.
Great.
Have a great day.
All right, bye-bye. Ms. Rios.
Yes, Your Honor. Mr. Shanks is 37 years old. He was working at Hibachi Kitchen as the manager for, I believe, 3 months before he was arrested. He has 3 children, ages 12, 10, and 2. I do understand that he has a good amount of cases. He had a toxic relationship with the mother of his children, back and forth, fighting between them. It just happens when the police are called, he's the one who gets arrested in this situation. But from talking to his mom, I understand that this is just an ongoing thing. I think the fact that they will not be able to have contact with each other going forward, this won't happen again. He doesn't have other, it's just a situation where it's just him and the mother of his children. It's not a situation where he's violent in regards to other things. There's no armed robbery, there's no aggravated assaults with other victims that are not a family violence situation. So we believe that the 5-serve-1 is a good resolution to the case, to the cases. We just ask that you accept the negotiation between me and the state.
Okay. What's your understanding of how this will work in terms of Mr. Shanks being able to see his kids?
So we discussed that briefly. I think his mom can be a medium person.
Okay, I want to put that in the sentence that the special condition of no contact with Ms. Sanders is no contact, and then we'll identify, and we can always modify it, but it would be, and we can put his mother's name in. This is the third party who is allowed, because technically that's indirect contact with Ms. Sanders if Mr. Shanks's mother reaches out to her to say, I'd like to get the kids so Mr. Shanks can be with the kids. That type of contact is okay, as long as Mr. Shanks' mom isn't saying, and I'm gonna kick your butt because you haven't been good to my son. We need to manage that part of it. But if she is a neutral intermediary, I think it's appropriate. They're not, well, this 17 SC case involved cruelty to children in the first degree. I don't know who the victim was in that. I'm assuming it's not one of his own kids, but I'll look at that in a sec. But assuming Mr. Shanks having contact with his kids isn't going to be problematic for him. Okay, anything else?
One thing I did want the state to read into the record, the cases that are now processing. I just want to make sure.
Oh yeah, can you read into the record the PI numbers? Well, I'll get to that. I have my own checklist here. All right, let me check one thing. What are the names of your 3 children?
Amari Shanks, Kinsley Shanks, and CJ Christopher Shanks Jr.
Okay, so they're all Shanks, not Chantel Dawson.
Yeah.
That's not your child?
No.
Okay, then I'm less concerned. Do you have any questions, Mr. Shanks?
So from the time I've served already from being in jail, will that count as far as like not just from this time, but from when I bonded out from the last time? I don't remember how long I was in jail, but
Probably, but let me tell you, I was just looking at your jailings. You've been in for 159 days since you were arrested in
29th.
Yeah, actually September 27th. You're getting credit from the 27th, which is that this case? Okay.
Yes, Judge,
You'll get credit for all of that time.
Yeah.
I'm looking at the other dates and like you were in for 31 days, but that's related to the Chantel Dawson case. You were in again for the Chantel Dawson case for 4 days. The only thing I've got in the system is the 159 days, which is a big number, that you were in because of this.
It was the bonded. I bonded out for the FTA that I was in jail as well.
Okay. Well, if it's in the system and it's related to this most recent case, you'll get credit for it. Okay. At a minimum, it's 159 days, almost half a year. Any other questions?
No, sir.
Okay. What other kind of work have you done besides being the manager at Hibachi Grill?
I was a kitchen manager at Gusto.
So you've got a background of restaurant management or kitchen management.
I did construction at the Four Seasons Hotel.
What are you hoping to do when you get out in terms of earning a living to help support your kids?
I have a settlement check I won't have to earn.
Pardon me?
I have a settlement check.
Oh, right. I forgot about that. And it's a settlement for what?
I fell at Publix.
You were a customer there or you were working there?
I was a customer.
Okay. And just ballpark, what is the settlement? Is it in the millions, the hundreds of thousands?
Hundreds of thousands.
Okay. And are you able to get it all at once, or it's the kind of thing where you're getting a certain amount each month?
All at once.
All at once. A lump settlement.
Yes, sir.
Okay. What's your plan to keep that in a safe place so you don't spend it all at once?
My mom currently has a vegan bakery, and she's been doing it for 8 years, so I plan on helping her get another shop open.
What's the name of the bakery?
The Vegan Sweetie.
Where's that?
1131 Lucid Avenue in Little Five Points, Emmett Park.
Know where that is? Okay. I don't think I have any other questions for you. You've asked me your questions, so let me march through my list here. Mr. Shanks, I find there's a factual basis for each of your cases. You and Ms. Sanders clearly had a difficult relationship. It sounds like are all three of your children with Ms. Sanders?
No, sir.
How many of them are with Ms. Sanders?
One.
The youngest?
3-year-old.
The 3-year-old, okay. Where do the 12 and the 10-year-olds stay?
With Alexis Wiltshire.
Okay, completely different mom.
Yes, sir.
So it's only the youngest, is that Junior?
Junior is with it's the Kinsley Shanks.
Kinsley is the 3-year-old. So that's of your 3 kids, that's the only one you need to go through Ms. Sanders to see.
Yes.
You can see whether the other mom lets you see the other kids has nothing to do with Ms. Sanders.
Yes.
It's going to make life simpler. Okay. How would you describe the relationship your mother has with Ms. Sanders?
She's neutral.
Okay, I mean, like they'll take each other's phone calls?
Yes.
Okay.
She can talk with her.
Is your mother the right person to designate as the go-between when you want to see Kinsley?
Yes.
Okay. What's your mother's name?
Lazandria Shanks.
Spell the first name?
Lazondria.
Like it sounds. Okay. And she's the baker?
Yes.
The vegan baker?
Yes.
Okay.
She was here at the last court date, so she's been pretty supportive.
Good. I'm glad she's invested in this. So I find there's a factual basis in your 4 cases. I also find that your pleas are knowing and voluntary. Ms. Rios, can we affix electronically your signature on all 4 documents? And Mr. Patrick, I think because you have paper copies,
I signed them.
is it all 4 or just the 3 accusations?
So we've got, 7, the 23 CR will need electronic.
Okay, but for the 325 SDs, they're right here. Okay. So please, so did Mr. Shanks sign them too?
He did.
Mr. Shanks, did you sign all 3 of the 25 SC cases indicating your guilty plea?
Yes, sir.
Ms. Rios, you did as well?
Yes, sir.
And Mr. Patrick?
Yes, Judge.
All right, but we can sign electronically on each of your behalves the 23 SC case, correct, Ms. Rios?
Yes, sir.
Mr. Patrick?
Yes, Judge.
Mr. Shanks?
Yes, sir.
Great. Mr. Shanks, you are going to be on probation for a while. I am sentencing you pursuant to the Probation Options Management Act, which means only that while you're on probation, if you have a minor violation of probation, you and probation will resolve that. But if it is a new arrest for anything or it's contact with Ms. Sanders, that comes back to me and we'll work through what we need to do with that. Mr. Patrick, does Ms. Sanders know that these cases are being resolved?
She does, Judge. She actually, during my conversations, it's my understanding she's leaving the state. Additionally, she asked for contact. State is not okay with that.
Okay.
And I explained that to her.
And she is an independent actor and she could at some point petition me to modify that. But for now, the start will be no direct contact with Ms. Sanders. You'd work through your mom on that. And if she's moving, I'm assuming Kensley's going with her, but their custody issues you can sort out. We're not gonna worry about that right now. But good for you to know that. Do you have a weapons carry license?
No, sir.
Can you please put on the record, Mr. Patrick, the PI or CP numbers of the cases that the state is no longer pursuing?
Absolutely, Judge. It's 24 PI 007151 and 24 PI 007159. And just to note for the record, in case those numbers are different than what Ms. Rios and the defendant had talked about last week, as I said, we found that we had more cases than we had incident dates. And so we had numbers were shuffled. Originally, it was going to be 5, 9, and 6, 0 that were being ENP dismissed. It's changed now that after we figured out what the dates were after the sheriff's office fixing.
Got it. Okay. Ms. Rios, there is a petition for adjudication of guilt in 17 SC 156213. That's a case assigned to Judge Richardson, where your client received a first offender disposition in November of 2022. It sounds like that court has been notified. We might handle that probation issue today. Your client actually has noticed that there is an effort to revoke his probation because of that petition. Are you okay if we proceed with that today?
Yes.
Okay. Mr. Shanks, I am going to follow the negotiated resolution. You're resolving a bunch of things at once. Some of these got to be a little too old before they caught up with you. Most importantly, they all involve this unhealthy, tumultuous relationship with Ms. Sanders that it sounds like is at an end. You understand that as long as you're on probation, which you will be for 4 years after you get out, you have to leave Ms. Sanders alone. If you show up at her door, you are violating your probation, and I will revoke as much probation as I can. You understand that?
Yes, sir.
Great. That doesn't mean you can't see Kensley. That just has to be worked through your mom. You're not texting Ms. Sanders. You're not calling her, where's my daughter, or anything like that. It all goes through your mother unless and until maybe you get a lawyer involved, because you have rights if you're the biological father. Lawyers can talk to lawyers about it. You may not reach out to Ms. Sanders about this in any way. Understand?
Yes, sir.
Okay. What I will do in 23 SC 191719 is sentence you to 1 year to serve. You will get credit for the time you have served since that September 27th, 2024 date. In 25 SC 001315, I'm sentencing you to 1 year to serve, and you'll get credit for time served from that same date, and that will run concurrently with the other case. In 25 SC 001316, that's an aggravated assault charge. Your sentence is 5 years to serve 1 year, balance probated. Special conditions of probation are 3. Most important, no contact with Ms. Sanders, with one exception. That contact can occur through your mother, Lizandria Shanks, and that's only about your ability to have time with Kensley. Your mom is not contacting Ms. Sanders for any other reason. That would be a violation of your probation. Okay? So that's condition 2. Your mother is the conduit. And condition 3 is you complete a family violence intervention program, and that you need to be enrolled in within the first 90 days of your release. Okay? And finally, in 25 SC 001317, count 1, your sentence is 5 years to serve 1 year, balance probated. Count 2 is the same sentence. Count 3 is the same sentence. And count 4 merges into count 1. And I'll probate those remaining 4 years. So overall, it is a term of 5 years to serve 1 year, balance probated, and you get credit for the time you've been in since late September of last year. I think, Mr. Patrick, I've covered everything from the state side. Anything you want to add?
Can't think of anything, Judge.
Ms. Rios, anything on behalf of Mr. Shanks?
No, Your Honor.
Mr. Shanks, do you know where you'll be living when you get out?
Well, I'll be living with my mom until I get my own apartment.
So you'll start out with your mom. What county does she live in?
She's DeKalb County.
DeKalb County, okay. Ms. Simpson is going to give you some basic reporting instructions for probation. Oh, before that, we need to handle 17 SC 156213. I will not revoke your first offender status only because you now have a whole bunch more convictions. There's really not a point in all that. What I will do, how much time remains on that case, Ms. Simpson?
2 years, 6 months, 29 days.
All right, I'm going to revoke 1 year of that probation. You'll get credit since you've been in custody, and I'm going to terminate that case. So you don't need to worry about being on probation in that anymore. You'll be on probation for 4 years, which is a lot more than is left there, through 2 of the cases you just pled to. So we're going to close out the 17 SC case.
One question, Your Honor.
Yes, ma'am.
Are we gonna run into the whole not getting credit for time served? I keep forgetting when that starts.
That's a good point. And if I revoke a year, he won't get credit for any of that. So let's not do that.
I talked to probation, they were fine with 6 months.
Yeah.
That way he would.
What I'll do is revoke 6 months of the probation. That's going to be close enough anyway, because you're not getting credit for time served. So that gets you to sort of 9-ish months there. But I'm revoking 6 months of your probation in the 17 SC case and then closing that one out so that you can just focus on your probation in the 2 cases you pled to today. Any questions about that?
So from revoking 6 months, that means that I will only have probation for you for this case, and I still get my time served for the jail time I have to finish, right?
Correct.
And that's you said 9 months?
No, I'm revoking 6 months in the old case you've got. If I revoke more than 6 months, it gets a little complicated with the Department of Corrections and credit and everything, and we don't need to go into that space because the 1-year sentence is what's going to control everything. The thing you're pleading to today. I'm just trying to close out that 17 SC case so it stops chasing you down. The remaining probation in that case